My lord. So there is a public role have been encroached.
Pass on all the memos. Pass on all the memos. Please call the list.
You want.
Let me pardon mention. I am in virtual lordship. I have to mention.
To file better application. Let it be not. Item 14.
Please for the other side.
This press and state lordship will stay. This is come for first time.
You are there. First time.
First time.
Yes.
Liberty, you see liberty to
Better application, better particulars.
The
I memo.
Yes.
Learned counsel for the petitioner is an appeal or a writ petition.
Writ petition.
Then the counsel for the writ petitioner submits that the that the writ petition contains fatal defects which are incurable in nature, and seeks for withdrawal thereof with liberty to file afresh. So leave is granted.
I am in virtual.
Fresh admission item number 1.
Lordship. To mention on matter, Lordship, I pray. It is a matter pertaining to the expert opinion submission before. That is the WBC number 746.
Madam, have you got the report?
Rescue has not been made.
We
Next, it is not like this on forum public notice, my lord, but a data.
how is PIL, sir?
Man, this is a public road, man.
True. Then there is already an encroachment proceeding which is initiated. PIL for enforcement to complete or dispose of. It is a normal writ petition, sir. It's not a PIL. What is the public element involved in it? Tell us.
Citizens are villages of.
Sir, I understand there is already an encroachment proceeding initiated by them. You wanted an early disposal of that. Is a PIL. I'm really surprised with this kind of writ petitions. Sorry, the day should not start with that. But what kind of, sir, please apply your mind, sir. You can move the writ petition, there is no difficulty. But public interest litigation.
Yes, general.
Dispose of, I'm not very strict in that. He has come. Lako. The instant writ petition is taken out by the petitioner, alleging apathetic as well as dormant attitude of the concerned officer in not bringing the encroachment case number for whatever, and encroachment case number such and such to its logical conclusions. Representations have been made to the concerned authorities, reminding them of their duties in bringing the proceeding to its logical end, yet there is no response. The counsel for the state submits that the moment the proceeding has been initiated, the authorities must show alacrity in disposing of the same at an earliest stop. In view of the above, the writ petition is disposed of, directing the concerned authority to dispose of the encroachment case number such and such and such and such within 6 months from the date of the communication of this order, upon adhering the principle of natural justice in accordance with law.
Item number 3.
What kind of is encroachment? A copy of the adequate general. Because the virus of this, the state act. You wanted that, why only the diploma, why not the degree will also be included as?
Yes, yes,
qualification?
Your Lordship, I need to go through it because I think there is a matter pending with the Supreme Court. I'll find out, Your Lordship. Let it come out another day.
Engineers things.
Yes, Your Lordship.
So only stating the diploma, that doesn't mean that higher qualifications can also be eligible for the
Yes, Your Lordship.
application, different applications.
Because if you employ a diploma holder, why don't you employ a degree holder? He's having more.
Decided on.
If my lords may
And
allow,
these are the engineering, because there's a specialized branch.
There is
my
I
lord,
think,
here two cadre rules in 2012 have been framed. One for diploma, where the junior engineer can go up to the assistant engineer, and for assistant executive engineer, where the degree holder engineers can get the opportunity. That rule is also there. What the degree holders now want, they want to enter into the cadre of the diploma engineers.
Just asking where is the difficulty? If a degree holder want to join as a junior engineer, where is the difficulty? After all, there is a promotional post. Junior engineer will be promoted to an assistant engineer post,
Yes, Your Lordship.
having a diploma.
But
Whereas there is another parallel or horizontal avenue of recruitment to the post of assistant engineer from a degree holder.
But this issue has been set at rest by the division bench also, man, of this honorable court.
Have you seen?
But I have
Let it come on another day, Your Lordship. We will discuss.
because I am aware of that particular educational matter which went to the Supreme Court, where in the primary education, the B.Ed was considered to be the mandatory, which the Supreme Court struck down that in the primary or elementary level, the B.Ed is not, because it has got a different, the approach to be made to a elementary level of education.
Yes, Your Lordship.
And the B.Ed, they are trained in a different manner. So that cannot be a criteria. But here, if they want, there's something more. And which is really attributable to the post. Junior engineers are discharging the same duties as of the diploma holder, that of a degree holder. Same thing. Engineers are engineers.
That way, Lata case was followed recently in this reference.
Let
Yes,
it
Lata
come.
was there.
We'll verify it, Your Lordship. To another date, Your Lordship. We'll verify the entire.
Instructions. When?
3 weeks after, Your Lordship, 3 weeks.
3 weeks.
Item number 4.
Item 4 is with regard to competence of the authority impose transport fee of the power flower versus all.
Counters in other cases.
No, not right. I have changed.
Now, there is already a judgment which is
Yes,
already
Yes,
delivered.
sir. I have given him that copy of the judgment also.
Send it to the authorities, Your Lordship, for verification.
That was in under earlier policy.
Yes, Your Lordship.
Now we change the policy and again we are bringing
Yes, sir.
up the same thing, which our High Court.
That's
And
it.
about in the year
That's a
2004,
company.
Your
The
Lordship.
authority has no competence.
20 years back, Your Lordship, 20 years.
Maybe,
Competence.
as long as that judgment stands.
If
Yes,
a particular provision is declared, it is not in accordance with the law. Later on by legislative exercise, can you bring it again?
Vis-a-vis the policy, it was, Your
Not
Lordship, in the year.
and it is involved that.
We have sent it.
Stand on a Wednesbury's principle. If it is found that it is not, then
The point involved has been whether the purchase of less than
No,
2
I
quintals.
understand.
Lots of sir.
the same order when 18 July.
Meetings to the.
Item number 5.
Five. Leaders. Arranging annex of 4, where the name of the schools and villages has been placed by another schools where it has been notified under annex of 3 for Godavari.
I could not get it, what you said.
Where the villages of this approach this honorable court to unveil challenging the annex of 4 order issued by the opposition number 3, wherein the school name has been replaced.
Express they decided first, now they have shifted it to white list.
Wait, yes.
You are agreed by this shifting. What is the policy decision?
Because the
Purely a policy decision. Which school should be declared as a model under this particular scheme as a model school.
Sir,
So it is because there are many factors that really.
but that's the reason that now really mentioned.
Initially,
Initially,
the decision does not contain so much of reasons for that.
page 13 of their school having highest enrollment strength may be considered on priority basis. This is the my year 400 students are in this that school. But
Maybe if the infrastructures are not up to the mark.
But that for that reason they have been consider our case for model school under annexure.
They might have gone with the numbers of the students who are there. Why you want a model school to be constituted? It is up to them.
No, but
Why your response, madam? Why your response to it? Let us see how much time you want.
3 weeks after. 3 weeks.
Absolutely. Yes.
My highly representation they been considered. Because they are shortly they are already.
No, you don't want the judgment on this.
Yes, yes.
You don't want to argue. Why not in X? Why it is in why they have changed their mind
Sorry,
to make it
that's
white?
better than against.
Rejoinder you would like to file. Rejoinder if any shall be filed within 2 weeks thereafter. 6 weeks.
Yes, ma'am.
Not a 2 year.
Item number 6.
I have filed. Sir, I have.
8 weeks.
Sir, I have filed, sir.
What Sir, if they have already started declaring one school to be a model school, they may also consider later on your school to be also.
So they first consider our schools.
I understand now it's a policy.
Then
If there is any absolute factor on the part of the government in changing the policy.
then
What's the cause?
may I pray, my lord, they can be consider my representation, so they may be disposed of. It will be, otherwise,
We wanted to decide a law that how far a citizen can approach in this way.
otherwise.
Very difficult, sir. Anyhow, come after the quick.
Item number 6.
Very your lordship. Relates to levy of water rate and compound interest under the Odisha Irrigation Act. So your lordship may see order dated 27/5/2025.
One time settlement.
We know there
Scheme.
we have applied and the government
Is there
advocated
any
they will
scheme,
take
one time
instruction.
settlement scheme under this?
They will consider our case and what is their.
Sir, what first thing, one and the foremost question we have to be satisfied is, what is your legally enforceable right to have your case considered under the OTS. First, you have to cross that hurdle. If you have a legally enforceable right, then we can definitely direct them to consider. Is there any one-time settlement scheme they have framed?
They have framed, my lord, and they have given it to other private industrial
Where is that?
undertakings. That is there, my lord. I have given
Show
it.
us.
My lord.
Your lordship have to see, because as the writ petition is at all maintainable at the instance of the petitioner, because the petitioner company is no more in existence. It is already taken over by the Aditya Birla Group. And that too, after clearing all the dues.
IBC or what?
No, no, my lord. That is the only one. This company has various establishments. So one factory in
Or by
Punjab that has been
order.
transferred. That is sold. One
Or
company is
takeover,
sold.
or
My
takeover,
It will not take
yeah.
over. Company has not been taken over. So one unit of the company was sold. The company is existing.
You are having a
But the
My
condition,
lord.
You are having a Annexer 6.
I am there before your lordship, my lord, for consideration of Annexer 9 city. 9 city on the ground that, my lord, on the ground that, my,
So 6 one-time settlement scheme has been brought into effect pursuant to this sports.
direction.
That's what.
My lord.
What is the resolution of 15 law?
That is, my lord, your
Scheme,
my lord.
which were having it, and that is continuing till date to show that.
My lord.
When have you
What I
applied?
want.
My lord.
When have you applied? Because
I have applied. Your lordship may see, my lord. Your lordship may see. Annexer 8, my lord. Page 41,
Mr. Sahu
my lord.
is 33.
My lord.
One time settlement of outstanding water bills of central government units, organizations in private industrial,
Right.
private industrial unit,
Yeah.
right?
Right.
So this, you are taking help of this resolution.
My lord, my lord,
So this has been extended
my lord.
for 10 to 10.
And last extension, my lord.
Ah.
Last
Where is
extension
the
is,
extension?
my lord, page 41, my lord, Annexer 8,
Annexure?
8, my lord, page 41,
41.
my lord.
So last extension.
Last
was,
extension, my lord, it was up to 31 May 2025. The last line,
For a period of,
up to 31st May
31st May.
2025.
so now what we are doing, when you find the writ,
My lord, we have filed this on 20,
No, have you
Annexer
filed
9.
application?
We have filed the application, my
When
lord.
have you filed?
We have filed on 25, 2025.
when you find a writ petition, sir,
After that, my lord.
then
25, 2025, we have made the one-time settlement of application is there, my lord.
have you filed a writ petition within that particular period? That is the 31st May 2025.
Yes, my lord.
Filed.
Yes, my lord.
When?
That is filed on
27th of. Or you not?
your lordship may
If it
kindly
is
see
not
page,
within the time.
it is
then
not
we have-
within the time, my lord. Page 41, your lordship may kindly see. Page 41, the last extension that is granted. The lordship kindly have a glance to para 3 of page 41.
Yes,
That resolution 25/3/25.
correct.
The state cabinet in their 62nd meeting held on so and so had extended the time period of one-time settlement for receipt of the application up to 30/9/2023 and settlement outstanding water dues till 31/3/2024.
Oh, so you say that anything which was pending
Yes,
up to 31st of March 2024,
yes.
those are coming within that particular purview of
Yes.
the OPS.
Petitioner never made application
If
within
those applications are pending, then those have to be disposed of within 31st May.
my petitioner only made application on
The
25th.
consideration.
What
And-
is the period? Just what was the period? What was the period of this levy?
This was up to 2009 to 2015, my lord.
And here the petitioner has cleared up all the dues. Now he wants the refund after 9 years.
Another writ petition is.
And
my
another
lord.
writ petition to that effect was filed in 2015 with
No, no,
self-same prayer.
where is the decision in his favor that this levy was not in accordance with law?
Yes, that is not.
Where is the decision?
He has never moved, and that writ petition is pending.
No. We have
Your
made.
Lordship, may kindly see that writ petition is WPC number 780 of 2016. That is pending, and there he has made the claim with respect to the self-same refund, and that writ petition is pending before this
And
one.
how the second writ petition lies?
Yes, my lord.
Sir, how the second writ petition lies?
No, we have made this application, my lord. The facts are like.
Yes. Are you claiming the refund of the same amount which you have claimed in your first writ petition?
My lord.
Then how the second?
No, I am coming to that, my lord. Let me, what has happened, my lord? Here, my lord, we withdrew the writ petition and made the deposit under protest, my lord.
Sir,
And there is a direction
Sir,
from
I
the Honorable
understand.
Court.
if you have already approached the court
My
by filing a writ petition seeking refund of the same amount, can you come again to the court seeking the refund of the same amount?
that is
Writ petition is not a duplication of the claim.
2016, my lord, that writ petition was filed.
Maybe
Pursuant to the direction of this honorable court, so the state government extended that OTS application to the private industry. That was in 2023, my lord.
Sir,
That was in 2023,
I am asking you, your writ petition is pending.
my lord.
Then, if there is any subsequent development which has taken place during the pendency of the writ petition, you know what is the course of action to be taken in this regard.
Your lordship may club up both the writ petition and take up next week, my lord.
We are strict. I am very strict. My
But
own
the-
judgments are against you. And I have imposed a very hefty cost for this kind of a writ petition.
Your lordship may call it next week, my lord, because
Whatever.
along with that writ.
In another court, the same thing was noticed and it was.
No, we have not suppressed anything, my lord. We have
It's not a
indicated,
question of suppression. It's a question of repletion or a duplication. See, the thing is, which I can read your mind. Since my writ petition is pending for more than 6-7 years, unlikely to be taken up and disposed of. So I have come up with a fresh writ petition. So it will be taken up.
no, that writ petition is regarding the refund on the basis of.
Then this writ petition is not for the refund.
OTS, my lord. This is for one-time settlement.
What?
One-time settlement of our due, so that the balance money can be refunded.
Then how you claim the refund in that writ petition?
That is basing upon the earlier order of this honorable court.
What? I am asking you, sir, you asked for a refund. Refund on what
Refund on the
basis?
basis of an earlier order of this honorable court, where we withdrew the writ petition with liberty that we are making the payment, but that is subject to recomputation of the levy.
Correct,
My lord,
correct. Then
No, they did
again
not-
you find a writ petition.
my lord.
Then again, what for?
They did not recompute. That
Correct.
is our grievance. That is why after depositing the entire amount under protest, so we approached your lordship saying that there is a direction for recomputation and they have not recomputed.
Correct.
My
Then now you want
Now, in the meantime,
so
my
that
lord.
the entire money should come back.
No, that your lordship may call it next week, my lord. Both the writ petitions will submit on my
No,
my lord.
no. We will strictly go by this writ petition.
No, your
And
lordship may
show
call
us that
along with
whether this
that.
writ petition is.
Along with that, my lord. Otherwise, along with
Show us.
along with 780 of 2016.
We will
Let
call
your
it
lordship
a
take-
file for a reference, but not to be disposed of.
There, my lord. My lord and senior Mr. B.K. Mahanti is appearing in this matter. So your lordship.
Is my own judgment, sir. She convinced me that I was wrong.
Will-
I am ready to change my mind. But you'll have to convince me that I am wrong.
This matter your lordship may call next week, my.
The moment we put you a difficult questions.
No, my lord.
But another aspect, as rightly pointed out by the last, that application was to be made in 2023 March, but you have made the application for settlement in 2025. So
No, that was,
Can we extend that time?
that time was extended from time to time. I think.
That is for the purpose of disposal of the pending applications. Not for making of fresh applications.
the prior paragraph you are not reading.
Paragraph 3.
But in between actually, my lord, there was another notification where the date of submission of application was extended.
So you have not made out a case like this?
Not your case.
Show us from the documents you have annexed that it was extended.
You have said that full bench of this court dispose of that earlier restriction. Pursuant to that, certain developments have added.
So I will try to convince your lordship on merit matter. Lordship may call it next week.
Well,
Subject to your lordship's convenience, my lord.
give that number.
780 of 2016, my lord.
780 of 2016.
The 5. It should
Yes.
not be tagged, but it should be why it should be brought to the court. Only for the purpose of reference.
Yes, sir.
Next month.
No, along with my lord.
Item,
My lord, along with read petition number 13833 of 2009, which was disposed of on 23/3/2015. There is a direction for recomputation.
Sir, we are required to see the pending writ petition filed.
Right.
We are not concerned with the disposed of this petition. No.
No,
item number 7.
we go. This is regard to the cancellation of the work that was given, it was issued. A central government said that they will take instruction. I don't today, I don't know, reply had been filed.
There is no order for.
My lord, the first order, if your lordship sees.
This.
He said he'll take it.
Yes.
My lord, the order is there, I'll just point out your lordship. That is order that is order dated 3/6/2025, your lordship.
This 6.
I think this is not working possibly.
G625.
May I place it with your lordship's kind for you?
G625.
My,
Individual.
during that issue. And on 10.
My lord, I am sorry, my lord. BC is not working. That's why.
It-
Today we are filing counter. The copy also serving to other side. Only he has executed 2% work. That's why
It is not bookmarked.
It is not also showing here.
It is. 3-6.
10-6 order.
3-6 order, thereafter 10-6. 10-6 because after vacation, my learned friend appearing for the central government says that they are filing the reply today. So just now they are serving a copy. So I need little time to respond to that, Your Lordship.
Where is have you filed it or you are going to
No,
file?
yet they are
today we are filing, my lord. Today we are filing. Already my associate is in court and will hand over to the court.
just handed over to my.
Served copy.
Yes, sir. It's
You file it in the registry.
This in the open court, rejoinder by 2 weeks.
Can it be settled that my lord after 2 weeks any date may be fixed with the tender matter get this stay order?
Yes, yes, Your Lordship may fix a date.
That should be fine.
Past July.
1st July.
Oblige, my lord. Oblige.
The interim order may kindly be extended.
Is there an interim order?
Yes, on 3-6. there was a-
Yes.
They've got the entry order, my lord.
Yes, till the end of July.
Man, so grateful, man.
No, it is already there. Till the end of July or until further order, whichever is earlier.
Man, so grateful, man.
My lord, till the next listing, authorize.
Matter will
What?
be decided before that.
So what I'm praying, my lord, first may fix the date, till that date may stay maybe.
No, we have already fixed a date.
Past July.
1st July. 1st July.
My lord, my lord, my lord.
Item number 8.
So grateful.
May I please allot it? Project of petitioner is agreed by an extra 11 my lord. That's a demand notice, my lord. My grievance is 3-4 my lords. First, my lord, the demand notice is arbitrary, unreasonable, my lord. It violates the tender terms and conditions, my lord. And third being, my lords, the principle of natural justice has not been followed before passing this order, my lord. An extra 11, my lord. A brief facts regarding this case, my lord. The petitioner was the L1 bidder, was allotted the work for implementation of this, my lord. And annexure 3, my lord, that's page number 162 is the letter of intent, my lord. This was for the redevelopment of a slum cluster, my lord.
Correct.
Mandap Basti, my lord.
Correct.
Though it was allotted 2015, my lord.
Yes.
Next, my lord.
And what was the period for completion of the entire
I'm coming to
project?
that, my lord. The lordship may kindly come to page 44, my lord.
That's the tender document.
Yes, my lord. Page 44, my lord, clause 1.4.
There was any work contract which was issued later on?
No,
Letter of intent?
No, my lord. Letter
No.
of subsequent letter of intent, no contract, my lord. This
No, letter of intent itself is a contract, sir.
Yes, my lord, please.
So,
Lordships, clause 1.4, my lord.
of
Please read that.
page,
Page 44 of my paper book.
yeah, no, 44. Instruct.
I agree, my lord.
So,
Or
20
from the
months,
date of handing over of the site by BNR to the contractor.
whichever is later.
Whichever is later, my lord.
Correct?
It's a slum dwellers were residing, my lord. It was the duty of the opposite parties to hand over me the site free of encroachment, my lord. The
Where
admitted fact
says-
is that
Was it a as is where is basis, the tender?
yes, my lord.
Was it as is where is basis?
Yes, my lord.
So
Yes,
you
sir.
knew that these are occupied by the slum dwellers?
Yes, my lord.
So you were aware?
My lord. It was the duty of opposite parties to handing over my site, my lord. After removing the encroachment, then my duty starts, my lord. Lordship, in the year, my lord.
Questions look very.
Yes, my lord.
That's both. Have you understood and replied?
Yes, my lord. My humble submission is that, my lord, it was enforced by the slum dwellers. It was the duty of BNR.
Sir, when you participated, you were aware that it is occupied by the slum dwellers.
But it was the responsibility of the BNR, my
Where
lord, to
is
use the
that?
encroachment.
Because it was there. Is handing over the site with the occupants, that's the slum dwellers.
My lord.
That was given to you at the letter. Where is the letter of intent?
Letter of intent, my lord, that's 162, my lord.
162. Yes.
Annexure 3. And it's an admitted fact, my lord, until 2021, my lord.
Yes, 1 minute.
Yes, my lord. I'm sorry.
So it was very much clear in the letter of intent that you'll have to start the work.
My
That
lord.
means that shows that the site was made available to you.
My lord. My lord.
So-
What I submit, my lord. There were 5 blocks. 1 to 5. For the block 4 and 5, my lord, the site was handed over to me in 2016-17. For which the work has already been completed and handed over by 2019, my lord. Regarding block 1 to 3, my lord, page 172. There itself admitted fact by them that until 2021, the encroachment was not removed. Page 172, my lord.
After receipt of letter of intent
My lord.
in 2015,
My lord.
have you raised any objection
Yes, my lord.
that it should have been free from all inconveniences and you have not handed over this land
May kindly say
free
annexure
from all,
4 series, my lord.
because letter of intent says within 3 working days or 3 days you have to start the work
My lord.
in 2015 itself.
My lord, please.
So
Lordship, may kindly see annexure page 164, annexure 4 series, my lord.
Sir, 172, you are referring it, that there are a clear stipulation made by them
Yes, my lord.
that it was made available to you with all compliments.
May I read, my lord?
Thereafter, your conduct has been shown.
May I read, my lord? May I read?
I have read it.
Since award of this work,
Yes.
almost 8.5 years have elapsed, my lord.
Okay.
Though the period of project was initially delayed for availability of clear front.
No, the period was initially delayed for availability of the clear front.
My lord.
But
Since
since
3.5 years.
last 3.5 years,
Yes, my lord.
the entire clear front was made available
Yes,
to
ma'am.
you.
They admitted
Till date, some pending works of 3 blocks, plastering and an entire
My lord.
finishing work for 2 blocks are yet to be executed from your end. Then come to paragraph, this is just after this paragraph 5.
submit. I'm coming to that, my lord.
But after repeated persuasion from our end,
Yes, my lord.
no effective productivity was observed at the work site.
I'm coming to that.
That means the site was
Yes.
made available.
2021, my lord.
Mr. Such and Such became non-responsive
My lord.
to all our telephonic communications, except 10 workers engaged for some insignificant works.
Lordship.
No site activity was observed as on date.
Lordship, now I'm coming, my lord. What the reason why this letter was issued, my lord? Lordship, there was a Lordship in the 2015, my lord. Lordship, may kindly allow me 2 minutes, my lord. It was allotted in 2015, my lord. They admitted that in 2021, clear site was provided to me, my lord, which is again not true, my lord. Next, my
That
lord.
is a disputed fact.
Yes, my lord. I'm coming to that, my lord.
So,
Next, my lord. In 2021, started working for the rest of the plots, my lord, there was cost escalation, which was within the tender terms and condition. I wrote to them, annexure 7. They never replied to it, my
that is a
lord.
different issue. That's a different cause of action. You are not pleading that.
Lordship,
You are approaching the court against an order of termination.
no, my lord. Not just termination, my lord.
What?
Demand notice also, my lord.
That is what is there.
Yes.
Demand notice means the termination.
Termination, my lord.
So,
Lordships, what I'm submitting, my lord, this demand notice, my lord. Lordship,
price escalation, that is between them, and there must be an arbitration clause.
Lordship,
I think in every contract nowadays with the
Lordship,
Page 109.
two clauses.
Page 109 has
Let us
arbitration
consider
clause.
2 clauses only, my lord. First, my lord, the clause 115, which is the source of this notices, my lord. Page 91.
yes, so the lackadaisical attitude, the dormant attitude which he has shown in not completing, not
Lordship, they
responding.
never agreed to.
You could have raised
It's
lot
a
of objections.
pre-GST tender, my lord. This is a pre-GST tender. Subsequent to that, I requested for cost escalation, my lord. They never pay heed to my request, my lord.
It's a different issue.
My lord, next, my lord.
That's a different issue.
Clause 115, my lord. Lordship, may kindly see clause 115.
So we
which is the
will
source of this
simply
notice.
direct them to consider and take a decision about the cost, the price escalation. This clause, let them take a decision. So far as the termination and demand, it will remain.
Lordship, what I am submitting, my
It
lord.
will
Clause
no
115.
difficulty.
Lordship, may kindly see clause 115, which is the source of this demand, my lord.
Where is,
For a
which
moment,
page?
Page 91, my lord.
91.
Yes,
Okay.
ma'am.
bring that 91.
But Lordship is page 100, my lord. Clause 115.
Anyhow,
My
bring
lord.
that 100.
Yes, my lord. Cancellation of the contract, full
Please.
or part, my lord.
Yes.
Lordship, next relevant page 101. The subclause B. May I say, my lord, that the risk and cost clause, by virtue of this, they have raised the demand, my lord. What it reads: the accepting authority may, without prejudice to any other right or remedy, which shall have accrued or shall accrue.
Which one? Where from you're reading?
Lordship, after Roman 10, my lord.
Yes.
The first para, which starts with the accepting authority. May I read, my lord? The accepting authority may, without prejudice to any other right or remedy, which shall have accrued or shall accrue hereafter to BNR and BMC, by notice in writing to cancel the contract as a whole or only such item of the work in default of the contract. The engineer in charge shall, on such cancellation by the accepting authority, have powers to, subclause B, my lord, carry out the incomplete work by means of risk and cost of the contractor, my lord. Next one is second paragraph. Any excess expenditure. This is to what extent they can hold me liable, my lord. Any excess expenditure incurred or to be incurred by BNR and BMC in completing the work or part of the work, or the excess loss or damages suffered or may be suffered by BNR and BMC, as aforesaid, after allowing such credit, shall, without prejudice to any other rights or remedy available to BNR and BMC in law, be recovered from the monies due to the contractor on account, or if such monies are not sufficient, the contractor shall be called upon in writing and shall be liable to pay the same within 30 days, my lord.
It's a liquidated damages.
Yes, my lord.
So
my lord,
what the contract says that you will complete the contract, the work within, say, the price X. You could not.
Yes, my lord.
Now they have to engage another person to complete it.
My lord.
Now that person charges X plus 1.
My lord.
So up to X immune.
My lord.
Anything which is plus 1,
grateful,
they can recover it from.
Grateful, my lord. That's what I'm saying, my lord.
So it's a matter. So let them decide. That's a question of the where is the arbitration clause?
Lots of arbitration clause is at, my lord, and moreover, my lord, the arbitration clause 109, my lord. 109, clause 126. 109, my lord. After the Supreme Court's decision recently, my lord, by a constitutional bench, this arbitration clause cannot be worked out, my lord.
They wanted to engage themselves.
Yes, my lord.
So where is the difficulty? But the clause would remain.
My lord, my lord.
You can approach under Section 11 of the Arbitration and Conciliation Act to have the arbitrator appointed by the court.
What I'm submitting, my lord.
So there is an arbitration clause is not invalidated by that.
Let me give it a chance to produce all those documents, my lord. Give me all those documents.
Raise that
they have relied upon, my lord.
before the arbitrator. It's a question of fact. It's a question of fact.
What I'm submitting, my lord. Before passing annexure 11, my lord, they should have given me a chance to go through the papers which have been relied upon by them, where they say that this is the excess demand, the plus 1, which my lords have rightly pointed out.
Then the definition of a dispute has to be diluted. If we accept your proposition of law, then there cannot be any dispute. It is a dispute which is to be resolved through a particular judicial or non-judicial mechanism. Then one has to understand that what is the meaning of the word dispute. What you say, then it is diluted to a great extent. You can go to the arbitrator, you can ask all those documents that what is the foundation of your claim, show us any damages which you suffered, you can definitely make a counterclaim.
May I submit, my lord? Humble submission is, my lord. This is a public authority, my lord. And any civil consequences has to be a reasonable order and has to be in compliance with natural justice, my lord. What I'm saying,
fair laws judgment of the Supreme Court, there are a lot of judgments even for the government. So the arbitration clause is there. If the parties have chosen a particular forum, then why the court will bypass it? Then Section 8 will come into play. We are also a judicial authority.
Lordship, then let them consider my submission with respect to annexure 11, my lord. Let them give the papers. If that is not resolved, my lord.
This is unnecessarily. If you say that they have not taken into account this document, they have not taken it out. They can place it to the
No, my lord. I'm not saying.
What access laws they have to complete that's completed will take into account the evidence involved.
But I'm submitting, my lord. Let me give me an opportunity, my lord. Let them show the papers by virtue they have arrived at annexure 11, my lord.
No, then that's why I'm saying the way the propositions, what is the concept of a dispute is there? A particular claim is made by somebody and the other side is denying that claim, that it is not substantiated by any reasons. That raises a dispute. And if the parties have agreed to resolve the dispute through a particular forum, then they have to approach it. It is not a one-way traffic in that way that they will make a demand in terms of the clause, and nobody will ask a question on that demand. They have to prove.
Had it not been a public
They have to prove by an evidence. So they will produce everything. If they cannot produce anything, ultimately their claim will fail.
What is small difficulty here, my lord?
You are really avoiding the arbitration.
No, not at all, my lord. Ultimately, my lord, they both will be going to arbitration only, my lord. What I am saying, my lord, we are trying to resolve the dispute before going into the dispute, my lord. Let them
that's why I'm saying you are trying to give or assign a definition of a dispute, a pre-dispute state and a dispute stage and a post-dispute stage. Then 3 stages. You are really trying to assign pre-dispute. The dispute has already risen. I have not come across a pre-dispute raise. Is a pre-arbitration stage I can understand. If the clause says that the parties would go for a mediation first, and if the mediation fails, that can invoke the arbitration. I can understand that the pre-arbitration stage there is a mechanism. But dispute I have not come across. Pre-dispute stage I have not come across.
That's what I am submitting, my lords. We go to arbitration, my lord. But I think Lordship may kind of protect me for at least 4 weeks because they will enforce the bank guarantee, performance bank guarantee, my lord.
It will be a greatest injustice one judge can do.
But also complications
If the court find that it lacks a jurisdiction to entertain by virtue of an embargo on the section, can it grant any interim order?
Lordship, then at least Lordship may direct
Can be grant.
Lordship.
We are talking about section 8 because there is already an arbitration agreement.
Small prayer, my lord. Lordship, through their demand notice, Lordship, we have already deprived.
If they waive it, we are ready to play. Let them waive.
Lordship,
The arbitration procedure, let them waive. They can waive. No difficulty.
So I will take notice. Let me take notice at least, my lord.
Who is for the other side?
It's for the BNR, my lord. Opposite party 1 is the proper party is opposite party number 2, my lord. BNR. Union of India, opposite party number 1, my lord. Because this is Rajiv Awas Yojana.
Mr. Nanda DSG, are you waiving your right of arbitration?
Well, there is a arbitration clause in page 109, 126.
Are you waiving or not waiving?
List past time without instruction, my lord, it is not possible.
No. Your decision that you do not want to waive, say us. If you want to waive, say us.
The party to take this is opposite party number 2, my
I understand. Union is also made a party. Let them. At least one authority's decision. Let us see.
Yes, Lordship may refer this matter or can issue notice and next day I will be or I take instruction, my lord, today.
You are not waiving.
Yes.
You are not waiving. Yes, that's a fair stand. We appreciate it. That you are not. Yes, now he's not waiving. Then arbitration clause becomes applicable.
Lordship, what I am submitting, my lord. To annexure 11, I have already given detailed reply by annexure 15, my lord. Let them at least
come to a very premature stage. It is not a stage to.
It's not a premature, sir. It has matured to a great extent. It has got a lot of prejudice to them. Once the demand notice is raised, that means the cancellation of an agreement and invocation of some of the clauses where he could be put to
The penalty, my lord.
Financial liability.
Annexure 13, my lord. First they say that the
That can be taken
contract has been cancelled, my lord. Then while annexure 13, they are saying you execute the work within
If
the time
that
given,
is
my
so, then the
Annexure
section 9
13.
is there. They can go and approach the
Annexure
London
13,
court for filing section 9 application for necessary protection.
Lordship, can you say annexure 13 for once, my lord?
I have seen that.
Yes, my lord.
I've seen
Lordship,
it.
first annexure 11, they are saying,
I am at page 183 and 184.
yes, my lord.
Yes, I've seen
First,
that.
they are saying, my lord, the contract has been terminated. Then they issue a subsequent letter, my lord. By virtue of this, they are saying, complete this work within a stipulated time period, my lord. That's why I'm saying, my lord, this is not only unreasonable, but also arbitrary, my lord. They're the public authority, my lord. Case 184, my lord. Accordingly, the balance of the work shall be executed through alternate agencies at your office, for additional finance, so and so. Please advise that failure to mobilize and requisite manpower, material and plant and machinery to complete the work within 7 days.
This is for in relation to some other work.
Same work, my lord.
No.
Lordship, the subject.
Three sites. The 2 sites you did not touch.
Lordship, first, the letter of intent, same as annexure 3, my lord.
No, I understand.
Yes, my lord.
But they in their letter they have said that
Yes.
3 blocks you have done, 2 blocks you did not touch.
Yes, my lord.
And they do not talk about these 2 blocks.
But so once they cancel the contract, my lord, how can they enforce their right to force me to complete this contract construction, my lord?
This
Annexure 11, they are
This,
saying they are
this is-
cancelling the contract.
Then you say
This
that
is for a composite wall.
the partial cancellation is not permissible in law.
So,
Are you
Lordship, they are
contemplating
not
that?
clearing out, my lord. First, they are saying that the contract has been
No.
terminated. You pay a demand amount. Subsequently, my lord, after 2 months, they are saying
the notice demanding the recovery on a risk and cost clauses issued on 12/5/2025 is a subject matter of challenge in the instrument petition. A preliminary objection is raised on the maintainability of the writ petition. Stop. According to this Union of India, according to the Union of India, the demand was raised strictly in terms of clause 126. No, 100, page 109, 11, 1 point.
115, my lord. That's risk and cost clause.
Yes, which one?
115, my lord.
Clause.
Yes, my lord.
In terms of clause 115.
Yes, my lord.
In terms of clause 115 of the contract. And if any dispute is raised in this regard, the parties have chosen a forum of arbitration to adjudicate such issues. It is thus submitted that the writ court should not interfere with the contractual matter in view of the existence of a arbitration agreement. Stop. We find that the Bridge and Roof Company India Limited were awarded the contract to the petitioner is not represented today. Our attention is further drawn to a letter dated Where is that extension? 31st? Page 192. You say the extension of time.
That's not extension of time, my lord.
That is, you just referred the last one.
Yes, my lord. That's my lord, annexure 7, page 1.
Not 7, sir. You just showed me that it has extended till they asked you, even after termination, asked you to complete the
Yes, ma'am.
which page?
Annexure 13,
13 page.
page 183, ma'am.
Yes. Our attention is drawn to a letter dated 21st May 2025 with regard to the final notice at pre-invocation of a risk and cost clause because of the inordinate delay and the deficient performance in execution of the contract, wherein the time to complete the remaining unfinished work to be completed
Page 184, ma'am.
to be completed on or before 6 July 2025 in relation to a Mandap Basti Ray project. Full stop. The demand notice is issued on 12/5/2025 within the period of the said extension. The question which calls for consideration whether the authorities can invoke the risk and cost recovery clause appended to the contract before the completion of the project within the extended period. Stop. It further raises an issue whether such a factual dispute can be decided invoking the extraordinary jurisdiction conferred under Article 226 of the Constitution when the parties have agreed to resolve the disputes through an arbitration mechanism. Since the other respondents, then the Union of India is not represented, the petitioner is directed to issue a notice upon the other respondents. Requisites to be filed within 3 days from date. Matter is returnable after 3 weeks. For abundant precaution, we hereby make clear that all points, including the point of maintainability of the instant writ petition, are kept open and shall not be deemed to have been decided by us.
There's an interim application. You may
6, 7, you go interim? No, we are not going to.
Item 9, Abolishment.
Respondents, all the respondents. Yes, Paul,
Item 9.
Item 9, may it please your lordships. The petitioners before your lordships are the villagers of Pori Sankari Sai of district Jagat Singhpur, madam.
what is the representation? I am unable to read the representation.
Madam, I have given that.
Why you will not annex it?
Madam, I beg your pardon. So this is the representation. There are two sand places. One is Sanoberai and one is Forisankari side. Admittedly, the opposite party number 5 is the leaseholder of Sanoberai sand quarry. And Forisankari side, there is no sand quarry, it is just a sand bed, madam. So once the opposite party number 5 is done with Sanoberai, he is now excavating huge quantities from the Forisankari side sand bed, creating disturbances, pollution, and so also.
But that is not reflected in your representation.
Yes, madam. So
Please read it.
we, the undersigned individuals, would like to bring to the below stated issues to your.
Oh, you can read the original one slowly. I can understand.
It is difficult for me also to read.
Oh.
So let's had auctioned the Sanoberai and loading point for the period of 2024-25. The esteemed Tahsildar VDD had decided the boundary of the region from which the sand will be excavated. As the stocks of sand in the region have completely been emptied, the authorities having the rights of that region are now illegally exploiting the sand present under the areas of the Forisankari Sai village. These incidents have been reported multiple times to the concerned authority, but no action has been taken. Instead of that, innocent civilians have been jailed due to pressure of sand mafia and the authorities. The students of
Jailed means what?
they have since they were protesting, some FIRs were lodged and they were taken into custody that they were protesting illegally.
Correct. So then,
And the students of Parvatipur Forisankari Sai High School face various difficulties as the school is located near the riverside. We have informed you about the said incidents on 5/5.
where is the ecological imbalance? Where is all these things? If they are doing some illegal activities, then definitely, and you are espousing the cause of the students, then is it not a class action?
Yes, Malas, there are
If it is a class action, will you not take a leave under Order 1 Rule 8? Until that leave is granted, it is a stillborn proceeding.
Our Malas, the grievance have been ventilated before the collector Malas.
And you are espousing the cause of different. You says that since they were continuing with the illegal activities of
illegally
excavating the sand, so students have suffered. You do not know what sufferance.
It is not only the students, but also
But
the
if
village.
you say that it disturbs the ecological balance, this will bring some kind of a augment to the global warming or something.
It also the state is also losing the revenue. It is not only the villages because
So then how the PIL comes?
why the PIL comes
That is what I am saying, that PIL must be of such nature.
Yes, Manoj, sir. Since they're illegally excavating the sand, there is huge.
So authorities will take action against them.
Yes, sir.
If
But
they are permitting, if the quarry permit is given to them, then you can't raise in a PIL in this way.
no, Manoj.
Unless
Sanoberai sand quarry, there is permit. But towards the Forisankari Sai village, there is no permit. And that is not a
where is the
quarry.
evidence that they are already excavating the sand? Where is the evidence?
The whole thing has to be taken by the controlling authority, which is the
Everybody,
collector.
this
But
can't be.
no grievance which is being addressed by the collector. They have already represented.
What are you saying? We are not very happy with that, but at least if they are doing an illegal activities, that's your responsibility to check.
He has only made representations.
It's a different. So what is this? This is one translated copy. This is another. Both are not the replica of another. One has more words and sentences. One has less.
Manoj, there are three representatives.
You want my brother to read a less than me to read more.
No, it's
Then-
Both are addressed to collector.
Oh, it's the same.
Both are addressed to collector.
yes, Manoj. It is
How- how-
annexure
how come-
page
How
14.
come it will be a different one? Sure.
Page
We are
number
showing it.
14, how can you make two different translations?
Actually, there are two translation. It is for page
So you have stated this.
Sir, my
Annexure 3 phase 14 inches.
wrongly, my
What you
must have
say?
been written by.
Except making allegation against copy number 5, there is nothing in record to show that the illegal mining is being carried out. However, if the villagers have brought this to the notice of the collector, let the collector take a decision by giving a
You
reasonable
just, you
opportunity to
take an
occupy.
instruction. Tell us if their allegations are not substantiated, is not correct. Come and say that it is not. And if it is correct, then at least some steps have to be taken. It's a loss of the state exchequer in the state exchequer. Why?
Under appeal information. You have stated that the other part is not in Cyrus source.
It is not the Syrah source.
Source.
Yes.
So obviously when sand is extracted from that source, which he alleges, if comes out to be true, then that is illegal.
Yes, but regarding that extraction, regarding that illegal extraction, no document have been enclosed except making an allegation or a representation. That is what I am saying. But in any case,
He has to take instruction.
I'll take instruction.
Take instruction. Pass the point.
That. The sand from Sanoborai. It's he has undertaken illegal mining of sand from Harisa. Drawing attention to information. Let's see. Under correct information by the subgroup. There will be very clear for example, sand side. Was new service source. Referred to the year 2021-22. No, for example, no service source is in the name of what is enforceable. No? Mr. Das seeks to obtain instruction with regard to the extraction of sand from what is some side sand source. Is this
Eight. Item number 10.
Essential notice on the election warning challenge.
Just opposite. His grievance, the earlier matter, no steps are taken for illegal extraction of a sand. Here your grievance is that I am doing and extracting the sand.
No, not at all, man. I am carrying the.
What is this laterite stones?
I am not illegal possession of the laterite stone.
But that has been taken over by the National Highway authorities.
Till that no highway has been constructed was because only notice has been given. My kind you consider, my lord, the 51, what is the 51-1 say? Annexure 4, my lord. Yes. Send a notice under 51-1.
Yes. That is quoted. That is quoted in the
my lord,
petition. Paragraph 9.
My lord.
Yeah.
But I am neither transporting nor extracting. I purchased for the construction of my house. And when the notice is sent by in Annexure 3 by the Tahsildar, the NHA will construction on my plot. That is the reason I have not constructed my house. And they send a notice under section 51-1 that is not according with law, my lord.
No,
And now,
right.
my lord,
Why you say it's not in accordance with law?
Because 51(1) says, page,
You take a plea before the authority.
but if the
Take a
total-
plea, the show cause you are challenging, you know, the jurisdiction or exercise of power under Article 226 against a show cause notice is very limited. It cannot go, it cannot be expanded.
Not at all.
And you have already given a reply. Let them take a decision. They may ultimately drop, they may continue. It's up to them. What do you have done?
Next one is the final order, and in similar
Final
case, the coordinate bench has passed this order, your lordship may kindly see during vacation,
In your
where my
reply,
land senior was appeared.
in your reply to show cause, you have
Yes,
made it clear.
but that reply is not accepted by the authority, madam.
You have made clear to the authorities that you have purchased it
Right.
from somebody.
Madam.
So that evidence has to be
But
examined
they,
by the authority concerned.
No. This is a different one.
My lord, after considering the so.
Here, the show cause notice was issued.
Yes.
He has given a reply.
Annexure
But
one
later
is the
on,
order.
I do not find any decision is taken by the authority
Annexure one, my lord.
Where-
Annexure one.
because everything is in a vernacular language. I am unable to read it. That's the whole. Even a show cause notice, I am unable to read. Or a reply given by him.
I'm placing the crux of the matter.
Annexure
They have
one
said
is
the
the
wife
final
will not
order.
accept it.
I do not know what is that. It is in a vernacular language. I can't. Can you give me a translated copy of that? All the annexures are in a vernacular language.
Don't have, I will file, file it taken up.
Where is the final decision taken on the basis of the show cause?
But that is annexure one.
Okay. What is, can you read it slowly?
Yes.
Sir, one, he has given Zima, not final decision.
They say that the wife firm will not accept. That is the reason they have mentioned.
No. What is written?
ଆପଣଙ୍କ ପଚାରତେ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ନିମ୍ନ ସ୍ୱୀକାରକାରୀ ଆପଣଙ୍କୁ
A bit louder.
କରାଯାଇଥିବା କାରଣ ଦର୍ଶାଅ ନୋଟିସ ବାବଦରେ ଆପଣଙ୍କ ଉତ୍ତରର ସମୀକ୍ଷା କଲା ପରେ ନିମ୍ନଲିଖିତ ନିଷ୍ପତ୍ତିରେ ନିଷ୍କର୍ଷରେ ଉପନୀତ ହେଲେ ଆପଣଙ୍କ ଦ୍ୱାରା ପ୍ରଦାନ କରାଯାଇଥିବା ୱାଇ ଫର୍ମର ନକଲ ଗୁଡ଼ିକ ଆଇନ ସମ୍ମତି କିମ୍ବା ଗ୍ରହଣ ନୁହେଁ ଆପଣ ଏତେ ମାତ୍ରାରେ ମାଙ୍କଡା ପଥର that is laterite stone ଜମା କରିବା ନିମନ୍ତେ କୌଣସି ଅନୁମତି କୌଣସି ଅଧିକାରୀଙ୍କ ଠାରୁ ନେଇ ନାହାନ୍ତି. So that is
So
what
I understand. So for stacking that particular laterite stone, there was no permission,
Yes.
nor there is any authority which was given for
that is
that.
what they have said. Now challenging the similar order, if another for whom my current senior was appealing, that case I have given that they had approached this honorable court, and in that also the honorable court has taken note of Rule 46.
So the final decision has been taken.
Yes, the order is
There is alternative remedies available for
notice, not academic law. My respectful submission for Lordship is, they are the landlord officer, mining officer. How I am a layman, Marks. How they such issues that type of notice, which is not.
Where are the invoices for purchase of this laterite stone?
Yes, that is annexure 2, man.
Sure.
Yes, man. Bonafide, I am the bonafide.
No, just that is a steel and mines.
Yes,
department, transit pass.
Why?
What it says, where is the description?
Why?
Please show us where is the description of the material. Laterite, minor minerals.
Yes, madam.
Yes.
Why is the shows that I am the bonafide purchaser of the laterite stone, madam? That is
Where is the invoice, sir?
Why? For the purpose of.
Where is the invoice?
This is called invoice in their language.
This is.
Why is the invoice by the mining officer, madam?
Transit pass cannot be construed to be invoices at any time.
And this is issued in respect of one Narendra Agarwal, from whom the petitioner claimed to have purchased.
Oh,
I am
These
purchased from
are the invoice.
lease holder, madam.
So that's why I'm insisting upon this.
right of assignment shows.
That he is the lease holder.
No, whatever. He has a right. Shows.
Because I am purchased from him
He is the bona fide leaseholder and
What is
purchase from by.
purchase invoice, sir? In your favor.
Purchase invoice. For why is called the transit pass and purchase invoice not?
Sir, transit pass can never be construed to be invoice in your favor. Title passes through transit pass.
No, what my understanding is concerned, that for why is
Your
the
understanding is
transit
more-
pass basing on which I am the bona fide purchaser from the
Sir,
leaseholder.
your understanding is no understanding unless you support it.
Is he a trader of minor and minerals? Has he got that particular license granted by the authority?
That is not the question to be decided because he did not deny that I am not the bona fide purchaser.
There is
Because they are not disputing the.
A person will still be regarded as
As a bona fide purchaser, he purchases a prohibited goods. Because he has bought it from a particular person. Can he be said to be a bona fide purchaser?
But they are not. They are not saying they are bona fide purchaser.
So,
They say the
you
notice.
can't say you are a bona fide purchaser if the item which you purchase or the goods is not tradable, not to be sold, not to be done in this way. Can you say?
Lordship may give liberty to file an appeal before the mining officer. Right to mine. I never feel that no process.
Item 11.
Till then, well. This short period was given only that period, no course of action will be taken by the authority.
If we have relegated you to a statutory forum, then we will not pass it. Not. Yes.
Item 11.
Delay, if anything, can be considered. That part can be observed. Or delay part can be observed.
Oh, that is no difficulty.
They consider if any delay is there, then
They have a right. They have a
right.
No.
Observation.
There is no difficulty controlling the delay.
Lots of observation give me benefit that delay consideration may be considered favorable. Only that part I pray for lordship.
Don't worry.
Consider the delay.
We will take care.
You lordship observe, then it is easy for me to take care of that.
No, don't. Okay. Yes.
Was item 11. Very quickly. Lords, here, the petitioner.
Now, we wanted that legal extraction should be stopped. You wanted the legal extraction should also be stopped.
No, my lords. The government is not putting this quarry to auction
You are
because
saying
it is
that
near a
all
dam.
the query permit activities.
He is an ex-MLA, my lords. He writes to the government and the government also asks the authorities to inquire into the matter. If your lordship kindly sees annexure to at running page 15. But there is a sphinx-like silence, my lords. Nobody is bothering about this issue and everyone is silent, man. So they have to give a reply as to
What is the issue?
The issue is, my lords, reflected in my representation. The quarry, my lords, they are not putting it to auction because it is near a dam, it is near fertile agricultural land and habitation, human habitat. There is human habitation.
They have decided not to.
They are not putting it to auction. Now what is happening?
Why they will put it to auction?
Now what is happening, my lords? They are some contractors. They are showing false work orders, taking quarry permits under rule 34. These are all temporary quarry permits. So they are doing extraction without the mines being put to lease. They are taking these materials out and the mines are being operated. But the government has decided not to put the mines to auction because of the ecological hazards. Para 5, my lords, annexure 1 at running page 13. Annexure 1 at running page 13. This is my representation. The present petitioner's representation.
Raising a dispute that it is, they are doing it on the basis of fabricated documents.
That
What
I have to take instruction. On that question, I
Immediately stop it.
no, your lordship,
Stop it.
without instruction, I cannot submit as to whether.
So we are keeping it for 2 days, you come, because
But your
if it continues, we will not permit this to be.
I understood, man.
done in this.
I understood, man. But your
If
lordship,
you have permitted, no difficult. If
Yes.
you have not permitted, and
Yes, ma'am.
those documents are used,
yes,
it's
man.
a serious issue.
For a moment, man. Your lordship may kindly see annexure 1. My learned friend was
Yes.
placing.
I'm looking at it.
There.
I'm reading at the second paragraph.
Yes, at the outset, I wish to highlight that apart from legal review, the mining officer and the district deputy mining officer are issuing query permits based on fabricated work.
That is what a
That's the
document.
allegation.
That's a,
So I'll have to take instruction over there. Without
that is what I'm saying. Take instruction within 2 days and come
Yes,
back.
yes, yes. 2 days.
Come back.
So,
No.
3-4 days.
You have to. This is serious issue.
3-4 days of now.
Come on Friday.
Yes, yes. But this doesn't go coherent to an actual 4 that it is vernacular area.
No, vernacular road, I'll give you lordships. Those
It's a different.
that
come with
representation
that.
by the villages.
Once the serious issue is highlighted, we'll definitely
Well, we'll
Friday.
take it. That's what your lordship
Serious
will
matter
do.
on Friday. To take instruction by the state. Yes, call. Item number 11 was the last.
In this case, in publicated petition, there is a various irregularity committed in the public work, the Gram Panchayat.
Manrega.
Yes.
Yes, what is
I'll
this?
take it. First.
Yes, after 3 weeks. Take instruction.
Item 13.
May I please note, here the annexure 1 I am challenging, that is the forward option sale order, that is 25/3/2025, issued by opposite party number 2 in favor of opposite party number 3, which is the highest bidder man. My grievance is that as per the forward option notice at page number 27, point number 7, that is the payment terms, that amount has to be deposited within a period of 10 days, my lord. It has been clearly mentioned. The entire page number 27, my lord. Page number 11, my lord.
Yes.
I am one of the bidder. The problem is that the opposite party number 3 has extended that period.
So that is within their time.
Yes, my lord.
They can.
But, my lord,
Extension can be done by the
that can be done. The
issuing authority.
the extension is given there, my lord. Right below that, my lord, at page number, point number 7, that it can be extended.
Oh.
However, as per my information, at page number 5,
Yes.
there are several extensions. However, there is one extension is allowed in the notification, my lord.
Where it says that it can only be once.
My lord, at page number 28, there,
Yes.
it is written that if a customer fails to make full payment within original or extended payment.
Correct. If they continue extending the period, it is within their domain.
My lord,
It is within their domain. Had it been a clause that the extension can be granted once, then I appreciate that what you say, that once it is extended, it cannot go in a perpetual manner.
My lord.
But there is nothing. It says only the extended period. So if the power to extend is given, unbundled,
But it
then
is
in that event,
mentioned
where is the difficulty?
It is mentioned that request for extension, my lord. Only
Yes.
one extension.
Where is the one extension?
Not
Show
specifically
me that.
mentioned it is one extension, but
Where is
one
that?
extension.
Where is that one extension?
No, that is not specifically mentioned. That it
Then-
has to be one.
then-
But the language itself says that original period, that is at 10 days, my lord. Then after that, extension period, that has to be done. But
So
they have-
you are saying it is in a singular manner it
My
is
lord.
used.
My
Under
lord.
the General Clauses Act, the singular means the plural and a plural means a singular.
But it depends upon the situation. But here, my lord, when the situation, my lord, another problem is that, my lord, the original period, the stipulation period is 10 days. However, Here, my lord, there are several extensions which is going beyond the 10 days. My humble submission is your lordship is that the extension should be.
Has he deposited?
Here, my lord, state is not a party.
State is not a party because opposite party number 2 is.
Then why you are not making him a party?
State has not been made a party.
Oh, and the extension is given by them.
By steel authority.
Steel authority of not steel authority of India, but
So steel authority are there. Who is representing? Have you served?
They put separate. No appointment.
Then notice has to be given to them. Notice, 3 weeks.
I have filed an IA for stay.
Not a good case to anyhow. Yes, 3 weeks.
Item 14.
Same one. Just say another bidder.
Yes.
Identical issue, another bidder.
Item 15.
Your Lordship. Lordship, the petitioner is challenging the order dated 2/6/2025, your Lordship, at Annexure 4, wherein demand has been made for penalty, your Lordship, of 2 lakh rupees. Your Lordship, the brief fact of the case is that the petitioner is the lessee of a stone quarry, or as well as the owner of the truck which was carrying the stones from the stone quarry to the crusher unit, your Lordship. Your Lordship, when the vehicle was intercepted, your Lordship, a demand was made for a valid transit pass, and the driver produced the transit pass. However, the only grievance is that the transit pass was valid till. However, the situation at hand is, your Lordship, that during monsoon season, your Lordship, the roads are in dilapidated condition, and it is not the case that the driver could not produce a transit pass. In fact, the transit pass was there. However, there was a delay.
Pass actually, whatever my land friend submits from the document, it is clear that transit pass.
Whatever, sir.
Yes,
sometimes the Google map does not really reflect the exact distance and the time to be taken. Sometimes if you go on a Google map,
Too much congestion, but if you travel, there is no congestion.
Yes, yes.
Sometimes it says blue,
There are
no congestion, too much congestion.
There I don't dispute, but the distance that.
Do you go by it or? Whether your authority will.
Feel better if I'll take instruction of the authority.
Go on Friday, take it. If you can withdraw, then it's.
Right.
Otherwise.
Right.
Then only things will be written by us.
Friday, your lordship.
So
in a
that
position.
may
I understand.
Friday to take.
That's right.
Item 16.
There is order between 13(1). That is Annexure 23. Annexure 22. Let's say kindly look at. Page 85. The order speaks for itself, but I'll just place the order. Still it is operative.
So
For 5 years.
This HARISH source has been stopped operation since 2021.
You have.
No, they directly did stop it. Till that period, the money has already been paid. Royalty and everything has been paid. Thereafter, they have not granted me the permission to run it. There is no EC. I have also indicated in several times. But I have requested them to withdraw it, give it in somewhere else. When the sand is not available, no EC is available. They themselves admit it.
What is this EC execution?
Sir, the environmental clearance.
Environmental clearance.
But they themselves know about it. They have also indicated the order. If you also look at page 85, a similar matter came during the holidays, vacation. You also already issued notice and stated. But kindly look at page 85.
Yes.
they themselves admit the first paragraph, last but one sentence. The lessee has already paid the royalty and other charges.
21 and 21, 22 parts.
Yes, right. But thereafter, it has been stopped.
Where do I get it that it was stopped?
Yes, that exactly I wanted to bring your notice. So kindly look at the later dated. So page 58.
58.
Page 58, annexure 6, 5/4/2021.
Yes.
So you are instructed to deposit such an amount by 7/4/2021, failing which your lease agreement will be cancelled. You are further directed to stop operation of the Cyrus source with effect from 1/4/2021.
So you deposited that amount?
It has not been operated thereafter. And money has been deposited, they themselves admit in that improved order itself. But I would like to show you also
So this 1 crore 54 lakhs plus interest at the rate of 12.
Yes.
That is the condition precedent for cancellation. That is the condition precedent for cancellation of the lease agreement.
Yes.
And then there was an omnibus order that you will not operate.
Right.
So now this demand is in respect of what?
Demand is 6 lakhs. And demand, if you are saying, look at the improved order again. Kind of look at page 85.
Yes.
So last but one paragraph. Whereas despite repeated demand and so-called notices issued, the above mentioned query has no satisfactory.
Oh, this is for a future one.
Query has not been operated till now.
For financial year 2021, 22 to 24, 25.
No, not
so. But they have not lifted that particular the order stopping the operation.
Right.
Yes, madam. If you have stopped the operation, if they are not permitted, then how can you charge for a later period?
Right.
Well, it's only one submission, preliminary objection, madam. It's an appealable order under OMMC.
Appealable order.
And in that
if we say manifest injustice apparent on the face of the record,
exactly right.
Then why not we will invoke that purpose of Article 226. Alternative remedy is not an absolute bar.
I understand.
So in that event, it's an apparent manifest injustice. You have stopped the query operation from 1/4/2021.
Right.
How can you charge the query royalty or something post that particular period?
My lords, if I may, only one line from the impugned order, my lords, if I may refer. What has been referred is that the lessee has paid royalty for financial year 2020-21 and 21-22 partly, my lords.
True. For that, you can cancel the lease agreement. You can realize that particular amount by whatever the means which is available to you for that purpose. But you come to the next line. However, the lessee has failed to deposit such funds for the financial year 21-22 to 24-25. If you have stopped the query operation from 21, can you charge any royalty or any kind of a cess or a fees or whatever terminology it is used for the post period?
That's the short point.
That's the only thing.
My lords, I take instruction. My lords, when the hearing was conducted, they did not.
Have you lifted the query operation? That order of camp.
No, my lords, I have to
So
take.
stoppage you have done. How can you charge?
All these
It's not
information
unreal.
could have been given during the hearing, but they were absent during.
For what? For the purpose of those the demand when they were operating the query. No difficulty.
And then take instruction.
But if they do not, it's not that they have unilaterally stopped.
There's no
I can
allegation.
appreciate it.
No allegation.
If they unilaterally stop, that is up to them.
No allegation.
But, you have restrained him from operating. How can they? They can't defy your order. So Maybe that's a.
Consider was in session of.
Yes, my lords, now mining.
Now mining.
Mining
Because without verifying the original record.
My lords,
It appears possibly or.
my lords, I'll take instructions. my
Why
lords.
not the de facto doctrine will apply?
Will not verify the original record. Coming from.
My lords, let's take instruction, my lords, whether actually a cancellation proceedings have been taken effect for cancellation of this lease query or not.
So we have to stop the, we have to stay the demand. We have to stay the. That's absolutely unreasonable, unrealistic.
The only submission, my lords, is that during
There
the
is no,
hearing.
there's no document forthcoming that you have lifted that particular, the order, or you are not in a position to show any provision in the amended act which says that whatever the order which was passed by the then Tahsildar who had the competence at one point of time would automatically becomes vacated or nullified by virtue of the subsequent amendment. I can appreciate that.
Only, my lords, these all information could have been ventilated to the mining officer because
Why
notice
they-
was
why they
issued,
go-
my lords.
Why they will-
And they were
Absolutely.
absent. They were absent during, my lords.
For your ignorance, they have to approach the authority. It's a lapse on your part. Don't permit the ball to roll in a reverse direction. That they have to approach. It is you who have to take care of it. Admittedly, the query permit was granted to the prisoner for a period of 5 years on the basis of the agreement dated 12th December 2021. The royalty and other charges leviable on the basis of such agreement was paid for the financial year 2020-2021 and 2021 to 2022 part within that part. The demand was raised for the said period, but such amount was not deposited by the minister. As a consequence, as a consequence thereof, the query operation was stopped by an order of the Tahsildar with effect from 1/4/2021.
Yes, correct. 1/4/2021.
With effect from 1/4/2021. On the basis of an order dated 5/4/2021. The order dated 13th January 2025 is assailed in the instant requisition, whereunder the mining officer has competent authority raised a demand for the royalty and the charges reckoning for the financial year 2021-2022 to 2024-2025. It is the specific case made out in the retribution that after the aforesaid order dated 30, what is that order? Stopping.
Annexure 6, page 58, page
5/4/2021.
5/4/2021.
So, CORAM started. The minister was prevented from operating the mines for the purpose of query And therefore, the demand for the royalty and other charges post such notice is patently illegal. Full stop. We had an officer to produce the order dated 5/4/2021, where the authority not only demanded the royalty and the other charges for the period when the quarry was functional, but also restrained the prisoner from operating the mine with effect from 1/4/2021. The authority, now, a prima facie, we find that the authority cannot charge the royalty or the other charges post the restrained order. More particularly, when the authority itself has put a deterrence into the petitioner in operating the quarry or the slash mines on and from 1st April 2021. This, according to the senior counsel appearing for the petitioner, such restrained order has not been recalled and lifted subsequently. And in view of being operative, till date, the authority cannot approbate and reprobate at the same time.
But they have taken note of that also. Order, they mention it is not.
Counsel for the state, however, submits that they have to, their submits that they may be permitted to take an instruction on the core issue as to whether that restrained order was subsequently recalled or not. Stop. Let this matter be listed after 3 weeks to enable the counsel for the state to take appropriate instruction. Since we have found the prima facie case having made out, there shall be stay of the demand on the basis of an order dated 13 January 2025 for a period of 6 weeks from the or until further order, whichever is left.
But I'm SP, Mr. You said indicated.
Oh, name. I always write senior army.
It's all right.
No, give the name.
In the appearance column.
Sir,
No, no.
Column.
yes, sir.
Item number 17.
No, give the names.
Is not.
May I please? Yes.
17.
May I please know?
Why the sale notice to be called?
Well, the subsequent sale notice under Annex 5 is being assailed, my lord. For the reason that, my lord, Lordship may kindly must turn to Annex 1, my lord. The first sale notice dated 16/7/2024.
Yes.
My lord. And the petitioner, my lord, having been selected, he has deposited the amount, my lord, and after that a public objection was called for. My petitioner is, my lord, under Annex 3, page 20, Lordship may kindly see, for that is there, my lord, the table is there, serial number 2, my lord, Annex 3, page 20, my lord. The objection was called for by the collector, and the learned collector also under Annex 4, my lord, he has specifically observed that these two shops are not viable and these two shops has to be abolished.
What?
These two shops has to be abolished. The shops situated at
Page.
page, my lord, that is page 32. No, my lord, that is the first.
No, first same notice
Yes.
is at page A.
Yes, that is the report of the collector is at page 23. Last but one paragraph, page 23. It is worthwhile to mention that in the meantime, that paragraph. But you may have a glance.
You are concerned with this.
Sukinda CL shop and Rogadi post shop, both. Two writ petitions are there, madam.
Page 22, with regard to Sukinda,
Madam.
observation is the licensee could not deposit. That's why it was not renewed.
Yes.
That is the reason.
And he did not left the minimum guaranteed quantity, and therefore they refused to renew the lease for 24-25.
Yes, madam. That is one of the reasons, madam. And the
No, that is the reason.
lordship may kindly peruse page 23, madam. Page 23, the last but one. Yes, that is the conclusion paragraph, my lord.
The conclusion is based upon the finding which is recorded at the bottom of the 21 and the beginning of the 22.
Yes, and he has my lord, and he has observed in the last paragraph, of that particular report, my lord, page 23, it is also mentioned here that there is no scope and hope of continuance of the shops for the remaining period of 24-25. Thus, it is recommended that above two shops, namely Sukinda and Rogadiposi CL shops of Jajpur districts, may kindly be abolished for the year 25 and 26. This ends year, my lord. The report, as per the report, and immediately after the report, my lord, again on 35/5/2005, again they have gone for a sale notice with regard to the same two shops, my lord. Rogadiposi and Sukinda. That is there, my lord. Lordship may kindly peruse. That is page 32 and 33. (32) is Rogadiposi and 33 is, my lord, Sukinda. Same shops.
Therefore, the recommendation made by the collector, it is not a decision of final decision.
No,
The
it is a report given by the
recommendation may be accepted by a higher authority, may not be accepted by the higher authority.
It is
If they have decided to go for a fresh tender, I mean the fresh application to be invited, very difficult. The language you will kindly consider, it is simply a recommendation by the collector. It is not.
Yes, madam. It is a report of the collector.
He says that this is the report, may not. But the ultimate authority can take a decision. There is no difficulty.
The collector is also a party to
whatever.
The collector is also party to that.
So what?
No notice, madam.
That's the decision which the higher authority has to take. He is not a final authority for the decision.
No.
He is simply a recommending authority. Is it binding? Not binding. No, it's not. Yes, they are going to live. They are not applied. There is no question of relevant. And then say that it is in the rural area, I recommend that it should not be willing to reach. But ultimately, we have No, sir, it's very difficult, sir. Yes, sir. It was mere recommendation. It is not a final decision.
I am not saying that.
So
The collector has observed something.
that recommendation does not mean that it is.
This contradicts, the observation of the collector contradicts the news.
No,
That's what my.
He says that for the time being, but later on the government is thinking about the exchequers. Why there will be a holiday for the exchequers? No. Cannot be. Let the government.
Well.
Right. The first news that you could buy. You should buy the collector in the system registered charge was given by the excise section for inviting an application from the intended participants for repeat sale of the country before shops in the state district. Under the Odisha Excise Act 2008. And the rules frame thereof. The challenge is basically founded upon the assertion that the Odisha was allotted the country liquor shop in Sukinda and Ragadi Pusi. And was continuing to operate the same until the application for the shifting of the shop was rejected by the authorities. The matter was considered by the district excise officer. Wherein it is found that the minimum guaranteed quantity which is to be procured by the petitioner was not strictly adhered to. Cynical, and such being the condition to sue, not only for continuance of the license, but also for renewal thereof. Come on. The prayer for renewal was not acceded to for the year 2024-2025. So the detailed finding in this regard is elaborated by the state district excise officer in its order dated 30th February 2025. With the recommendation that the aforesaid two shops being situated in the rural area may be abolished for the year 2025, 2026. The aforesaid observation gives impetus to the genesis of the grievance raised in the instant petition, more particularly when the authority issued a sale notice dated 31/5/2025 for granting license for the year 2025, 2026 to the intending participants. It is vociferously submitted by the council for the Orissa that once the recommendation is made to abolish the shops in the aforesaid area within the Jajpur district for the year 2025-2026, it is inconceivable and improbable that the authority would proceed to invite the applications for granting license for the shops situated in the aforesaid area. It is trying to mention that the recommendation to abolish the shops by an authority cannot be construed as a final order. Unsusceptible to be changed and or interfered with. The recommendation may be accepted or may not be accepted by a higher authority. And therefore cannot create a legally enforceable right into a third party. The authority higher in hierarchy may accept the recommendation or may take an independent decisions, divorce such recommendations, considering the various aspects, including the loss of the government exchequer. In the instant case, the authorities have decided to invite afresh applications for the aforesaid shops, taking into account the recommendations so made, which cannot be impeached solely on the ground that adherence to such recommendation is inevitable. To stop. The renewal for the subsequent period was denied on the premise of a violation of one or more conditions enshrined in the license having granted to the prisoner, which is not a subject matter of challenge in the instant petition. Since the recommendation was merely an observation, it does not confer any inchoate right into a third party to seek mandamus for its strict adherence. we thus do not find any merit in the writ petition. Then is hereby dismissed. No other execution.
The connected matter.
Same.
Same. Both are same.
Item number 18.
Public interest litigation, petitioners are the representatives of the villagers.
Explosive license.
My lord, without any explosive license, occupant number 10 is blasting there. Without following
That is in a stone quarry area.
my lord.
So the explosive is to be used.
That
How you will break the stone?
my lord, guidelines is that more than 500 meters, within the 500 meters of locality, there should be no blasting. And
Then how the quarry is to be done? If it is a stone, I can understand is any other thing, it's a stone, then the quarry has to be stopped within 500. So you are really trying to achieve something indirectly which you cannot achieve directly.
Dwelling houses are nearby the
You
area.
have to ensure all the safety measures. Those are all required. So safety measures have to be taken and ensured. But you can't stop. You are doing whatever is to stop the quarry.
Without blasting,
Can it be done? A stone, how can you break it? There's a big stone.
by the machineries,
There is a casualty. If the stone immediately that the base is removed, then what will happen?
occupant number 10 has no license for explosion. Kindly see
That
Annexure.
is different. We have not made out a case like that.
Kindly see Annexure 3.
What do you say, sir, madam?
My lords, hearing would.
Don't go by our observations, sir. Come up large.
My lords, if I may refer to Annexure 6 at page number 27,
Yeah.
all the objections have been taken care of and thereafter a order has also been passed, my lords, in this matter.
Where?
Page number 27, Annexure 6, my lord.
Occupant number 3 is taken.
Just wait.
Here also we have made.
Just 1 minute.
Yes,
Just 1 minute. Oh,
Page 28.
impersonating somebody you have done the representation.
No, my lord. Yes,
Sir,
yes,
some of the representation, the villagers says that they are unknown to the fact that any objection petition has been filed in their name. And says that the signature made in the objection petition are false and fabricated. And says some of the signatories of the objection, they do not stay in the village.
Here, given the temporary license, but without providing any
Say
license.
so, your grievance is.
My lord, kindly see Annexure 3, page 19. We have obtained the information that no license issued for blasting.
Just. This was, there was a consensus which was arrived. It says that the mining activity would be done by a drilling and the blasting in a very low intensity manner. And they have also agreed that if there is any damage to be caused to any of the property of the villagers, they will remedy that. What more you want?
My lord, we are not obstructing the operation of the quarry.
it is mandatory.
Annexure 4 and page 22. Annexure 4, page 22.
That's a guideline.
That guideline says that 500 meters away from the place of blasting as well as from the place of quarrying. But as per the RI report on annexure,
No, it is says that the no blasting shall be permitted if the public road, railway line or any human settlement is located within 500 meters of the quarrying site. That is what is there. That you showing, you are saying that there was no license. Show us that for this explosive, use of explosive, the license is necessary. Guidelines also does not say so. Show us that it is mandatory.
residential houses are within the 180 meters.
Sir, you are not taking what is passing through my mind. You are showing an RTI reply saying that no license is granted for using the explosive. Show us that the license is necessary for using the explosive in the mines. First thing is that the license is mandatory. Then we can go forward. To us. Guidelines does not say so. It simply restrict within 500 meters if there is a railway line, if there is a public road, or if there is a human settlement. Then as in the public meeting, they have accepted low intensity charges and other thing. No, you have waived your rights, sir. Will you not, whether you were a part of that particular discussion? Then who are you? You were not heard when this order was passed on 25/2/2025. So you did participate. You participated in, and thereafter, how can you challenge?
Thereafter, we have repented to the office with two
Sir, there was a consensus which was arrived. There should be something. You can't take a rebound and then say that no, it's not. It says at the end, the villagers of the Salavida. Are you a villager of the Salavida? And the Dharapada. Are you not? They were present in the meeting, also submitted an application that they have no objection if the temporary explosive license is accorded in favor of such and such for blasting in leased stone quarry at both villages. Though some of the villagers were not in favor, but considering the view of the majority of the persons, and also the fact that the objection petitioners have done false signature of the persons, they say that we can't stop, but these are the conditions. They will not do any drilling or blasting during the night hours. Blasting would be conducted with a low intensity charge, and they will take all preventive measures.
So within the parameters, guidelines given on the guidelines.
So representation pending before the collector, let him to consider.
How many times they will hear? Then what has to be done? Please kindly consider. If we direct the representation to be considered, then again the authority will call all the villagers, not you. And they have already done, this exercise was done. You participated there. It is not that you did not participate there. What is the fault? Why you will interfere with this order, which is a consensus order? It's a review, which is not permissible.
No, regular investing, the dwelling houses are damaged.
Despite having participated in the hearing held on 25/2/2025 on the basis of an objection raised by the several villagers of Salavida and Dharapada
and Pendapada.
And the Pendapara. Honda part, no? The Honda part.
In the district of
Comma, the resolution which was, the resolution which was adopted there is sought to be challenged in the institute. The dispute pertains to the mining activities of the respondent number, SRCS, SRSC.
Occupant number 10. Occupant number 10.
The opposite party number 10. For blasting in the area of AC 10.320 in the lease stone quarry at Salavida village, recorded under Khata number 145, plot number 263 by 1, is a Honorable Roman 3 under Harish Chandanpur Tehsil. Perfect. Being violative of the exclusive rules 2008. The mass representation was made raising an issue on the blasting at the said mining site by the said opposite party number 10. And on the basis thereof, the sub-collector of Kyonjar district issued notice to the villagers as well as the
ए वर्ष खाली वार रे गला ए वर्ष न 25 रे जेति केला
astonishingly
टेबल हो 26
in course of the hearing
स्टार्टिंग
some
से
appeared and raised a serious issue on their being reflected in the signatures.
India Pakistan solla
According to
Israel
they are unaware of any such objection.
Israel Iran
Against the opposite party number 10 and their signature. Is false and fabricated. In spite of such serious objections having been taken in course of the hearing, the authorities proceeded to hear the be an integral part of the said representation / objection. A consensus was arrived that in order to streamline the smooth operation of for which the valid license is granted by the mining activity shall remain suspended.
American China.
Indirectly America Trump Pakistan को support करछन
Meaning thereby that there shall not be any drilling or the blasting activities.
ओबामा जो मझिरे आइले टिके इंडिया को सपोर्ट देले नले अब अमेरिका
फर्स्ट फेस्ट डोनाल्ड ट्रम्प का इंडिया
It was further blasting which is inevitable for mining activities
China, Russia, India
conducted with low integrity charge. Low intensity charge.
China ତ କରୁନି but
more preventive
China
measures,
occupied ଆଉ Pakistan occupied କରିକି
including
ଚାରିପଟେ ଇଣ୍ଡିଆ ଚାରିପଟେ ପୁରା
causing of any
network କରୁଛି
would be taken
ନା ଗୋଟେ ଅର୍ଗାନାଇଜେସନ
and will ensure
ଆପଣଙ୍କୁ 1000 ଟଙ୍କାର ପ୍ରଫିଟ ନେଇକି ଆପଣ ପଇସା ଦେଇପାରିବେନି ଆଉ ଆପଣଙ୍କ ଜାଗାଟା ନେଇଯିବ
ଗୋଟେ ଅର୍ଗାନାଇଜେସନ କରୁଛି ତା ଦେହରେ 3 ଜଣ ପାର୍ଟ
though some of the villages are not
ଚାଇନା ଆଣ୍ଡ ରଷିଆ
addendum to such
ଗୋଟେ ଅର୍ଗାନାଇଜେସନ
consensus having arrived,
ଯଦି ଅର୍ଗାନାଇଜେସନ ଟା ହେଇଗଲା
Yes.
G7 sir এই ଅର୍ଗାନାଇଜେସନ ଟା ହେଇଗଲା ପୁରା ଆମର କଣ୍ଟ୍ରୋଲ ହେଇଯିବ ଏସିଆ
are to be accepted. And on such score, used in writing, which is the subject matter of challenging resistant petition. In a democratic polity, the majority decision is binding is binding. And once the decision has been taken that mining activities would be undertaken.
ଦୂର କୋଉଠି 13 ନମ୍ବର ଏବେ ଯେତେ ଲାଗୁଛି ସବୁ ଶସ୍ତାରେ ସବୁ ଘର କୋଉଟା 7,000 8,000 10,000 ପ୍ଲଟ ନାହିଁ ଆଉ ବି ପ୍ଲଟ ତ କରୁଛନ୍ତି 30,000 ଟଙ୍କା ଭଡ଼ା 25,000 ଟଙ୍କା ଶସ୍ତା ଘର ଆଗରୁ ଗଲା ଯେ ମୁଁ
The petitioner has not been able to make out a case that mining leases has not been granted to the opposite party. Nor have been able to.
সেটা বেশি প্রবলেম করে
Of the statutory provisions.
সো বুড়ার পুଅ ভারি সিরিয়াস কাম আট অপারেশন ହେଇଛି ଟୁ লিভার দিটা ট্রান্সফার হয়েছে সিসিপি কি একদম তার অবস্থা কোর্ট বসছে না আইটেম 96 টা আইটেম কথা
Undertaken is strictly within the guidelines framed in this regard. And once the decided strictly make a strict adherence thereof. Simply because some of the persons have shown their dissent does not invalidate such a resolution.
ମୋର ଯୋଉ ଲିଷ୍ଟ କାହିଁକି ଚିଠା
The real motive is made patent that the petitioners are interested in stopping the mining operation. Being oblivion of the fact. No, oblivion of the oblivion of the fact that such mining operations are undertaken strictly in terms of the statutory provisions.
Subject complaining
The court should not go by the implicit of the
sanctioner of the bill, bills.
The statements made by the unless
government opinion.
It is
চিঠি নম্বর আমি কোন
proved by opposite evidence
sanctioner
that such
resolution
mining activities
ପୁଣି ଚିଠି ଡାକୁଛି ପୁଣି ଗୋଟେ ରିମାଣ୍ଡ ହବ
Or undertaken.
ଏ 7 ଦିନ ପରେ ତାଙ୍କ
in gross
ଚେୟାରମ୍ୟାନ
violation of the statutory.
ଚେୟାରମ୍ୟାନ ଆସିଲା ପରେ ତାଙ୍କୁ ଆମେ ଦେବା ସିବିସି କୁ ଯେ ସମଥିଙ୍ଗ ମାନେ mischievous there that's why
Since all
ଆଜି
the
ଗୋଟେ ଆଇଟମ ଥିଲା
taken the decisions in presence of the villagers of the
ନମସ୍କାର
villages
ଏଇ ଜଷ୍ଟ କୋର୍ଟରୁ ଫେରୁଛି ଆପଣ 30,000 କରୁଛନ୍ତି
and recording the consensus
ଦର୍ଶନ ଭଲରେ ହେଇଗଲା କିନ୍ତୁ ଆପଣ ଆଶ୍ଚର୍ଯ୍ୟ ହେବେ ଆଜ୍ଞା ଆଇଡିପି ରେ ଜଣେ ଏଏସଆଇ ରାଙ୍କର ଅଫିସର ମତେ ମିଛ କହି 5,000 ଟଙ୍କା ନେଇଗଲା
of the villagers
ମୁଁ ଆଶ୍ଚର୍ଯ୍ୟ ହେଇଗଲି ତାକୁ କହିଲି ବି ହଁ ମୁଁ ମାନେ ଆଶ୍ଚର୍ଯ୍ୟ ହେଇଗଲି ତାଙ୍କର ଜଣେ ଡେପୁଟି କମାଣ୍ଡେଣ୍ଟ କୁ ଫୋନ କଲି ସେ ଚିହ୍ନା ପରିଚୟ ଥିଲା କୋଉ ଟାଇପ ଅଫିସର ଡେପୁଟ କରୁଛ ତୁମେ ମାନେ ସିଏ ମୋ ପାଖକୁ ନେଲା ମାନେ କେତେ ଲୋକଙ୍କ ପାଖକୁ ନଉଛୁ ଚିନ୍ତା କର ହଁ ଲଜ୍ଜାଜନକ କଥା ଏକଦମ ପୁରା ଦେଖୁଛି ଆଇଟିବିପି ର ଗୋଟେ ଏଏସଆଇ ମତେ କହିଲା କେଦାରନାଥରେ ଆପଣଙ୍କ ସକାଳୁ ଦର୍ଶନ ପାଇଁ 2,500 ଟଙ୍କା ଡିପୋଜିଟ୍ କରିବେ ମୋ ସାର୍ ଆମେ ମାତାଇ ଯାଇଥିଲୁ ମୁଁ ତାକୁ କହିଲି ଠିକ ଅଛି 5,000 ଡିପୋଜିଟ୍ କରିଦେବି ତାପରେ ମତେ ନେଇ ସେ ଯୋଉ ଭିଆଇପି ଲାଇନରେ ଯୋଉଟା ସେ ମୁଁ ଆଉ ଜଣେ ଆରଏସଏସ ଜଣେ ଲୋକଙ୍କୁ କହିଥିଲି ସେ ବ୍ୟବସ୍ଥା କରିଥିଲେ ସେ ପୁରେଇଲେ ଆଜ୍ଞା ମତେ ଆସି ପଡିଲା କାହିଁକି ସାର୍ 5,000 ଟଙ୍କା ମୁଁ ରସିଦ ନାହିଁ ନା ରସିଦ ନାହିଁ ମୁଁ କାଲି ପୁରା ତୁମ ରସିଦ ଦିଲ ମତେ ଦୀପ ଯୋଉ ତାଙ୍କ ସ୍ପେଶାଲ
Item number 1. Pastor matter item number 1.
article called
challenging Annexure 2, which has been issued by the Procedural Judicial for illegal extraction, royalty and other charges for illegal extraction of 7500 cubic meter of sand rock. On the ground that the Tahsildar lacks jurisdiction to issue this notice post amendment of the Orissa Maintainability Constitution. Hello?
Tahsildar is not competent after that amendment.
Mining officer has been now interested.
After
So
2022.
when it takes effect from this date,
So my lord, it's still amendment of 2022.
22,
Yes,
then
ma'am.
why in 2025 the Tahsildar is issuing those?
To that effect, I have
No,
to.
because there are some cases of.
My lord, I'll check my lord.
Is there any notification
Yes, my lord.
that is given a additional power of the mining officer to his person?
No, my lord.
No.
No, my lord.
I have annexed it. It says otherwise no. Annexure 3. Annexure 3 available. Instead the mining officer is a competent authority.
Where which rule?
Annexure 3 page 13, my lord.
Yes. Which rule?
Orissa Mine and Mineral Concession.
Oh, which rule? The clauses are there, 1, 2, 3, 4.
Clause 2, my lord.
Yes.
The authorized officer means the director of mines and geology or any officer duly authorized by the government in writing for the
That
purpose.
is what I was saying, whether the Tahsildar has
No.
been appointed as an authorized officer.
Tahsildar has not
By
been.
virtue of this notification.
No, my lord.
The other person
In writing.
authorized by the competent authority or government, the finance department.
Is there any notification?
My lords, this what notification my learned friend is relying is correct.
Authorization.
No, my lords, as per my knowledge also goes, my lord, mining officer is the competent authority.
Been appointed?
That to that effect, I've asked the department, but no information has been received.
Fighting, let me just keep it.
Yes, ma'am.
Come on, fighting. Let her take instruction.
Another matter.
We can authorize, not necessarily that it should be.
Yes,
mining
that is an
department.
additional, that is additional authorization which is required. That I have asked the department. first.
Or any other provision which says the persons who work continue, they should continue.
No, there is no such
There is any notification.
No, there is no such provision.
Item number 20.
Make them not. Another single matter.
This was first person is going to happen. The department. Lordship, I'm appearing for the respondent with the Lordship's permission. I'm being led by Mr. Majumdar in this matter. So, with the Lordship's permission, can it be posted on some other day? If your Lordship is aware of the respondent. Next week, on the third, your Lordship. He has a fixed matter on his.
Third July.
Third July.
3rd July.
No. What about him?
I'll be Mr. Satpathy.
No, 3rd July is fine to you or what?
Mr. Satpathy is appearing in this case also. So I had to take a standing up. I'll be taking. Yes.
You just inquire.
I'll.
Then
Well,
let us tentatively fix on.
Third
July. Well.
So you both discuss on.
Item 24.
Obligation.
I mean, thought accommodation is out of station for some medical reason. Kindly cover us 2 weeks.
Your fault?
So, petition.
Yes. 2 weeks.
Item 25.
It will.
The public tax matter is similar, it has been accepted by, admitted by your court. The similar orders may proceed.
Yes.
Connected.
Both
the data.
Item 26.
May I please? Yes, sir.
My lord, I challenge the impugned order under Annexure 60 as without jurisdiction and against the principles of natural justice. Before coming to the merit of the case, I was outlining the gist of the GST laws. As per the meeting, GST Council meeting held on 9/1/2017, as well as 16/1/2017, the criteria has been fixed for division of taxpayers between the central tax authorities and state tax authority. As for the, in order to ensure the single interface of the out of total number of assessors or taxpayers, 90% taxpayers below 1.5 crores shall vest to the state authorities. 10% will vest to the central authorities. That to in respect of turnover of above 1.5 crores, it will be divided equally, 50% each center and state. Accordingly, the petitioner before your law has been administratively assigned.
According, let me understand. According to you, the resolution speaks about that any demand which is below 1.5 crores.
Any turnover.
Or whatever. It's a turnover of 1.5 crore. It will be decided by the state.
90% will be decided by state.
90%?
And 10% will vest to the sector.
Central. And thereafter, this 10% which goes to the central, exclusive. Not illegal. And above 1.5,
it will divide it
divided into central and the state in a rational manner or in a equal manner?
In the rational.
Rational means how much percentage will go to the center?
90%. 50% in case of turnover above 1.5 crores, 50% will go to center, 50% will
So it's equality.
Equal.
Not in the rational. Yes.
So accordingly, the petitioner before your law has been assigned administratively to the state authorities. It is not disputed. Your lordship for the movement.
Then why jurisdiction? So jurisdiction is appeared.
Yes, I'm just your lordship may kindly say annexure 9.
9.
What they are stating also. Running page 90.
Yes.
Mr. Taiwas Project Private Limited, plot number so and so, Kattak Road, Bhubaneswar, herein after effort as assessment, is engaged in supply of works contract service in form of construction to various departments, Government of Orissa, during the
period from July 2017 to March 2021.
And appear liable to pay
the GST on the
consideration received towards the said supply.
I think
the
government was approached that they have to reimburse the GST.
Their sole plea is that his contractor, my lord, he has not paid the GST, so that he could not pay. That is the gist of the matter.
So that is what I anticipated, that you did not pay. So he has not paid.
The government has
state government.
Means I do not know whether you represent the government or not.
Then your lordship may kindly for a moment. Page 92. Page 92. They are duty the so-called notice, they have admitted they have taken GST para 1. GST number such and such and are under the administrative of the control of the state GST authorities.
Right.
For payment of GST and compliance with the state of Orissa with effect from 1st July 2017 with declared principal business and such and such. They themselves admitted that the petitioner assessee is administratively controlled by the state authority. Now they are proceeding against the assessee by passing an impugned order on Annexure 16, and which is without jurisdiction because there is no notification for cross-empowerment. Also, what they did, they have, after knowing that the investigation has been started by the state authority, they directed the state authority to transfer the case from them to central authority, which is not in accordance with the law. As per the decision of the Honorable Punjab and Haryana High Court, Stalwarts Limited versus State Union of India, the lordship may kindly see.
Program.
In the case of a search seizure.
Search and seizure. When the even search and seizure.
This is a case of evasion.
Even search and seizure, even that, they cannot transport the proceedings from the state officer to the central office.
On the case when the officer who conducted the case and who conducted the search and seizure.
Yes.
They
cannot. Here, the officer of the state who has already initiated the proceedings under section 74 prior to investigation conducted by the central authority.
So during the initiation of proceedings only, both the authorities cannot.
Both of the cannot.
So one if concludes,
Yes.
the other can.
Other
The
state,
other is,
here the state
one has also-
can, state can.
Who says? It is the initiation.
Initiation.
It has not said about conclusion.
It is
If one authority has concluded, the other authority can initiate also.
No.
Is there any prohibition?
Because they have already initiated.
Seeks to, 1 minute, just I'm clarifying one thing. This seeks to, which my lord, my Honorable Justice Raman is referring, that relates to state taxes vis-a-vis union territory taxes. This is a case of Punjab High Court, my lord. And they have taken note of 6(2)(b), my lord. This deals with state taxes vis-a-vis union taxes, UT taxes, my lord, not central tax. If your lordship will see the head note, authorization of officer of state tax or union territory tax as proper officer in the certain circumstances, madam. So here it is a central statute, madam. Central.
They have referred to state.
Yes, state vis-a-vis union territory.
Union,
UT taxes.
same state.
UT tax act is something different.
Yes, something different. There is a fee tax. Union tax. Page 167 of the state judgment, paragraph 9. Impugn order annexed to 16. Final. 160. 167.
Yes.
Page, paragraph 19. We further notice that proper officer who has initiated proceedings in the present case is state tax officer. In our case, the state tax officer has initiated the first proceedings. Would be empowered to summon the persons to give evidence for the law. While the proper the other statutes provide transfer of case from one officer to the scheme of Central Goods Service Tax Act 2017 or Haryana Goods nowhere provides for transferring the proceedings from one officer to another. On the other hand, it debars the same. In the circumstances, neither any authority has the power to transfer the case from its own jurisdiction to another, nor any other authority can direct for transferring investigation and proceedings already undergoing before the proper officer in terms of section 6(2)(b) of the Act. Here, Annexure 7, the Superintendent of Intelligence, DGI, Bhubaneswar, has directed the state authority to transfer the proceedings from him to central authority.
People see the last paragraph, para 3 of that document to which my Lord Simil is referring. Since this office is investigating the GST liability of M.S. Projects Private Limited, covering the full period from July 17 to till date, hence it is requested to transfer the file to this office for complete investigation at this end. And pursuant to this, not limited. pursuant to this, he has transferred.
So there is no conclusion. Where?
My lord, page 85, paragraph, last paragraph, turning page 85, last paragraph. This is the request made by my intelligence officer to the state to transfer this investigation tax evasion report to.
It has been transferred?
Yes,
To
the
the
state.
state.
84
No,
page
from
84
state to center.
In 84 page, my lord, he has handed over all this report to my.
This is not permissible under the law.
My lord, which law that may?
That act, what is the act? What is the act provides that the authority, this is a judicial proceedings. Can it be transferred from one officer, proper officer to another proper officer? You saw the law. Already the state proper officer has already initiated the proceeding on under Annexure 3. For alleged short payment of tax prior to transfer.
Did you raise an objection when the file was transferred to the central?
No.
That you don't have, you lack jurisdiction, you can't do it? Did you
We
take
have
that-
five. We have five.
Where is that?
In
Because it issued to you by.
so far we have not filed.
Whether you have taken that plea.
No, we have not taken plea. Your Lordship, we have taken the plea before the investigation officer. Your Lordship may see Annexure 5, page 80.
No, you did not challenge that order of 25/6/2021.
Yeah, no.
That was transferred.
Yes, I'm not sure, because if at any time this is issue of jurisdiction. It can be challenged before
Then
Lordship.
thereafter, when they
Let's
assume
see
the
problem.
jurisdiction, did you raise an objection?
No, I raised the objection.
Suppose notice, there was-
I raised the objection in page 80. Annexure 5. That since the proper officer under the Goods and Service Tax has already initiated proceeding prior to summon for the period such the notice is not submitting the details further, as no proceedings will lie before your.
What? So you could have, because it was before the transfer was effected.
Yes, I have raised.
So once the transfer is made, then you are aggrieved by that. You should have raised an objection then and there.
That I'm not.
Because that was in the month of February.
Yes.
And the order of transfer is passed in the month of June.
Yes, ma'am.
So you did not,
question.
once you submit it, can you take a rebound and say?
Lordship, as you know, the question of issue of jurisdiction can be raised at any time.
I understand.
At the time of the
Collateral
execution.
proceedings that can be done.
Yes.
It was completely inherent lack of jurisdiction.
Yes,
If it
inherent.
is not inherent lack of
Yes,
jurisdiction.
inherent lack of jurisdiction, because
And
they
the
themselves
jurisdiction
admitted.
wrongly assumed or something, can
Your
you?
Lordship, they themselves admitted.
Otherwise have.
Otherwise.
They have otherwise a jurisdiction.
How can be?
It is not that they do not, they lack complete.
Your Lordship,
Lack of jurisdiction.
a single bench decision of the Honorable Madras High Court. They've decided after analyzing all the provisions, in case of cross empowerment, then they have the jurisdiction. In the absence of the notification,
We are on a different score.
cross empowerment achi.
Intelligence-based action, your Lordship, the intelligence-based action can be done by any of the authorities.
They may have the intelligence of, they may have the
jurisdiction, your Lordship.
They
There
may
is a
have the
notification
intelligence.
of CBIC.
They may have the intelligence, but
This is intelligence notice, focus notice.
they may have the intelligence, but that intelligence can be transferred to them. Your Lordship may kindly turn paragraph 61, page 125. After going through the various notifications, although it is a single bench decision, that section 6(1) of the respective GST enactments, they're referring to Madras, Tamil Nadu, and Central, empowers the government to issue notification on the recommendation of the GST Council for cross empowerment. However, no notification is issued except under section 6(1) of the respective GST enactments for the purpose of refund. Although officer from the central GST and GST are proper officer under the respective GST enactments. Paragraph 62. Since no notification has been issued for cross empowerment, with the advice of the GST Council, except for the purpose of refund of tax under Chapter 11 of the respective GST and read with Chapter 10 of the respective GST rules, impugned proceedings are to be held without jurisdiction. Consequently, the impugned proceedings are liable to interfere in the writ petitions. Thus, if an assessee has been assigned administratively with the central authority, pursuant to the decision taken by the GST Council, as notified by Circular 01/2000, bearing finance notification empowerment dated September 27, the state authorities have no jurisdiction to interfere with the assessment proceedings in absence of corresponding notification under 6 of the respective GST. Similarly, if an assessee has been assigned to the state authority pursuant to decision taken by the GST Council as notified by circular number such and such for cost dated September, the official central GST cannot interfere, although they may have such intelligence regarding the alleged violation of acts and rules by the assessee. The manner in which provisions have been designed are to ensure that there is no cross interference by the counterparts, only exception provided in 6 of the respective GST enactment. Therefore, in absence of notification for cross empowerment, the action taken by the respondents are without jurisdiction. The officer under state or central administration, as the case may, cannot assert the power of the investigation or adjudication of assessee who is not assigned to them. Therefore, proceedings initiated by the respondent so far against the respective petitions by the authorities, other than authorities to whom they have been assigned, are held to be without jurisdiction. That include proceedings warrant interference.
But the notification is also.
The Buhari two, four, two. Four.
Where have you stated? Have you stated that?
Yes, yes. Begin, in the beginning, yes. You will see my para one of the. Para one. In para one, I have stated. Received on both food.
Why you did not challenge it in before the appellate authority? What you were doing? Why you were silent?
Because
Why you
lack of jurisdiction.
No, sir. I have some doubts. I have some doubts unless you clear it.
I will clear it.
What doubts I have? Had it been a case that the authority lacks a complete lack of jurisdiction, that he cannot decide this matter at all.
He cannot.
No. He cannot decide a matter at all.
Your Lordship.
That is beyond the conceivable, the provisions of the law. I can understand is an inherent lack of jurisdiction. Yeah, he has otherwise a jurisdiction. Had it been initiated by him itself.
No, because it is.
You say that central. I have seen that Madras High Court judgment which you decided.
Yes.
There in paragraph, what you were saying, is quoted that there was a resolution or a decision taken by the GST Council, which says that if the turnover is up to 1.5 crores, then in that event, the 90% of the case will be dealt by the state, and the 10% cases will be dealt by the central government. So both have the paths, but it cannot be said that which one will go and which one will not go. If it falls within 10%, it will go to the central. It is all arrangement which has to be done by them. Now,
single
if it is more than 1.5, then both the state and the central equally have the jurisdiction. You cannot say that which will go and which will not go. So the jurisdiction is there. Only question is that suppose if the initiation is done by the state.
Yes, ma'am.
Please consider there is a line of distinction. When you talk about the jurisdiction, then the jurisdiction, there are distinctions. One is inherent lack. Second is a wrong assumption of the jurisdiction.
Yes.
And third is that improper exercise of the jurisdiction. In the latter two cases, you can't say the jurisdiction can be raised, except in one. Now, question is whether the state was competent to transmit or transfer.
Cannot.
So only thing is, it's not a complete lack of jurisdiction. It is a wrong assumption of the jurisdiction.
State cannot.
Is a wrong assumption of the jurisdiction. Whether this point can be waived or acquiesced by you in not challenging that order of transfer.
In case of jurisdiction,
you raised before it. You raised the plea of jurisdiction before it in the month of February.
Yes.
And then order of transfer was passed in the month of June.
In investigation,
you could have challenged that order of June 2021 immediately before the court.
I have raised this question before the investigation officer. Before the adjudicating authority,
that was in the month of, that was overturned.
In the month of
overturned, and then you accepted the order. Then you participated in the proceedings before the central. Can you fall back and say that this order of transfer is wrong?
In case of issue of jurisdiction can be raised at any stage.
Sir, the jurisdiction has a multifaceted.
Your Lordship.
The multifaceted dimensions.
Your Lordship, in this Madras case, the orders of adjudication have been challenged.
That is what I was.
74. Here the 74.
That is what troubles me.
Here the
Suppose
74
if there is no provision for a transfer of those investigation in the act itself.
Yes, my lord.
There has been an exercise of
My
let us
lord.
admit, let us go with the hypothetical situation. There is no express provision in the act for transfer of the proceeding from a central to a state or a state to a central. Let us see. Let us proceed. An order is passed. You did not challenge. You submitted to the jurisdiction. The moment the order went against you, you have taken a recall. No, that transfer is impermissible. Do not this concept doctrine of acquiescence apply?
Acquiescence apply.
Acquiescence.
Apply.
You accuse to your right,
But
by submitting to the
that
jurisdiction
would not
before the
confer a
central.
jurisdiction on the authority to proceed with the adjudication. Your lordship,
I have-
there is a second question. Lordship, second question.
I have little doubts.
I'll explain.
That you give me a clear pronouncement on this, because
I will
when I
start.
talk about a jurisdiction point, it's different. All these cases are,
I will verify.
that's a cross empowerment. It talks about the same.
I will
It says that
I will verify.
parallelly you cannot continue.
I will verify the other judgments. Your lordship,
But jurisdiction point is a different one.
Just 1 minute. Your lordship, I have no occasion to explain these things before the adjudicating authority.
Why not?
Yes, lordship, I will just explain.
You know that.
Explain it. The adjudicating authority who had the case has been retired, and the present adjudicating authority who passed the impugned order has never had me. He has never
It's a
issued
different
them.
issue.
He has never issued
That
them.
is a different issue. I can understand the principle of natural justice.
Yes, that is also there.
Have you taken that plea?
Yes, I have taken that.
Where? Have you stated it?
In the writ petition, I have changed.
Have you
Stated.
Yes. Have you said so? Sure.
Yes, yes, sir. Impugned order and violation, and
Where?
against the
Which paragraph,
principles
sir?
and against the principles of natural justice.
Please. Which paragraph, sir?
In paragraph 1.
1.
In other paragraph also I have stated. I've stated next. Just show.
No, sir. Paragraph 1, you have not stated what you are saying.
No, I'm just explaining.
Please.
I'm
Please
just,
show us from the pleading
Ah.
that the hearing was done by another officer and the order is passed by somebody else.
in the order
did not hear
itself,
you.
order itself, he has stated.
Please show us
Ask-
that you have taken a pleading.
I'm just sorry. Yes, paragraph.
I have read up to paragraph
30,
19,
paragraph 30.
33.
33. To the utter surprise of the petitioner, the Assistant Commissioner Suresh Chandra
Just. Yes, what do you say about this? How can it be done?
Let's see. So
This officer never heard that opportunity was not given to him. Can he pass an order?
My lord, your lordship
On the
is
basis of the
absolutely
pleading.
cannot, but your lordship will say, see, my lord, running page 160, my lord.
Paragraph 33, please answer.
My lord, I have that answer.
Have you given them an opportunity of hearing before you pass an order? Give. That's the only question. Yes or no given.
My lord, your lordship may kindly see, my lord, paragraph
I will
160.
not. Tell me yes or no. Whether any date was fixed for hearing.
My lord,
They were.
five dates are fixed, my lord.
By him.
By him or not, my lord, that
Is what I wanted a very clear cut answer.
My lord, by him or not, because what this order says, my lord, your lordship may place for a moment, my lord, this personal hearing paragraph 8, running page 160, it says personal hearing was fixed on 21/2023, 28/1/2023, 15/1/2024, 19/2/2024 and 8/8/2024 respectively. The authorized representatives, Sri Deepak Srushti Advocate, attended the personal hearing on behalf of the noticee on 22/2023.
These are all born from the record. I am asking you very simple. It is not his case that the earlier adjudicating officer did not afford an opportunity of hearing. Says he was.
Yes, madam.
He appeared, argued. But what his case is that he was later on transferred, he did not pass an order. It is
Whether this new
another officer who
incumbent
never fixed a date for hearing, passed an order. Is it permissible in law? Is it not a clear case
It is
of
not
a violation
permissible.
of a principle of nature?
It is not permissible, but I have to take instruction whether he has given issued notice or not. Because from this list of dates, my lord, only one date he has appeared. Whether all these subsequent dates, whether this officer has issued notice or not, that
No notice was
All settled down. All settled down. You must take a specific pinpoint case. Government. That he appeared before the predecessor, not the successor.
yes, ma'am.
So what remains for your?
My lord, only thing is whether he has intentionally not appeared or issued notice or not appeared. That is the only thing.
Then the officer would have said that on such and such that notices were issued by me, he did not appear. If he chose not to appear, then we will not go
That
in
is
his
the only
favor.
thing, my lord.
But
Whether
if
notice
it is
has
the fact that he never issued and simply passed an
my
order,
lord, then that will be wrong, my lord. That is the
then we can't. Then we can't.
Page 150.
Had it been a case that the predecessor has already passed an order,
Filing of the submission, he has himself said that no requirement of personal hearing.
Personal hearing has he given, the successor has he given personal hearing to the association.
I'm for the state.
in this
and
case, my lord, I have my lord, if your lordship, I have read my lord.
was given.
If your lordship will see, my lord,
Not that.
Annexer 15. Annexer 15/150, he chose not to give personal.
prayer clause.
If your lordship kindly see.
Personal hearing of the-
I am grateful, actually I have reached this point.
Mr. 75, Mr. Misra has shown 150.
150, ma'am.
What is the name of the authority?
It gets settled.
No, it is the reply. This is the reply submitted by the petition.
Which is, who is that authority?
It is online replies
You
submitted.
don't have the names, then you are arguing. Be sure, then argue. If you don't have, take instruction. Place the record. Page 151, some other officer, that is what you say.
I appeared before the case setting. No, personal officer, adjudicating authorities, Mr. Broad.
My lord, that
You see,
yes, ma'am.
you see 150 is dated 1/8/2024.
Yes, ma'am.
So how many months you took to come, pass an order? What is order in original? What is the date?
This 29/1.
After how many months?
25 months.
Then there is a possibility that the officer has got transfer and has not given him the personal hearing opportunity.
That particular, ma'am.
Then what are you arguing? That is the only thing
Yes.
you have to place clearly.
I have to take instruction whether he has issued notice, he has not appeared, or that one.
That is the only thing we are wanted. If he had issued a notice, after receiving the notice, they chose not to appear. Then you are correct. Then he can't take a plea. But if no notice was ever issued, and then straight away one fine morning you pass an order.
No, my lord, cannot.
Up to 11, more than 1 year to get the file pending.
Though the plea of jurisdiction is raised by the petitioner, but in course of the hearing, it was pointed out that the hearing was conducted before an officer who was later on transferred.
Retired.
or letter on debited an office after retaining superannuation.
Yes, ma'am.
And the subsequent officer, being the successor, without giving an opportunity of hearing, proceeded to pass the impugned order, and therefore the impugned order is liable to be quashed and set aside on the ground of violation of principle of natural justice. Your father, for whom?
My lord, I am opposite party number 5, ma'am.
The counsel for the opposite party number 5 submit that the issued order reviewing several dates having fixed for further hearing. But he is unable to disclose to the court whether such dates were fixed by an officer, by the predecessing officer, by the predecessor or a successor. In order to eradicate such confusion, he prayed for an accommodation to take the instruction. Let this matter be listed in the next week. We are fixing. Just on that.
Yes, ma'am.
Yes. On the ground of jurisdiction, sir.
I will challenge. I will also explain.
Sorry, sir. Then we will come with the plea of accusations.
Yes.
I will come ready with the plea of accusations.
Yes, I will come.
Next week.
My interim.
What? We are fixing next week. You have been waiting since January, February. No. You lost your right of statutory appeals. Next week we are fixing the.
We get party number 2 to 4.
Your name will be recorded.
Item 27.
I'm telling you, Jason, for condemnation of any filing from NB, I think income tax exemption. And similar matters are already been shut. Because of my lord in your order. The three matters are similar, man.
Yes.
Yes. Item 28.
I have to deposit 10% more.
Criminal.
Your option.
We are keeping this matter pending.
Your Lordship.
Some of the matters.
23rd June.
When to be discussed? 23rd.
23rd.
It is there.
Regarding GST RP cancellation, it must be for the order.
Yes.
Item 30.
The expert order. On the ground that parallel assessment proceeding can be made by two separate assessing authority. And also two assessment order, my lord.
What is the point?
And two parallel assessment proceedings made by two separate assessing authority, my lord. One ex parte and one attended by the assessing.
Same period.
Same period, same amount, same.
Two orders were passed.
Yes, madam. Annexure 1 and Annexure 2.
But
I am telling
is
the
succeeding, what is the Proceeding.
Initially, the Annex 3 was.
Expertise was proceeding.
My lord.
Expertise.
Proceeding, yeah, initiated by proceeding. So called notice.
So after hearing, another order was passed.
Yes, my lord, that is initiated first, the first so-called notice under Annex 2, initiated and it is participated by the petitioner. Thereafter, the opposite party one initiated separate assessment proceeding, ex parte, without service of any notice or any order. Thereafter, the order passed, but next 3 is the next 3 is the order which was participated by the petitioner.
Similar thing cropped up, Mr. Chiman was appearing, some of them. He was there.
Two parallel proceedings for the same offense.
Inspection does matter because there are 4 states involved. Petitioner address is at Telangana. He has executed works contract in the state of Madhya Pradesh. And the Annex 2 that is issued by Maharashtra. And in Raurkela, the Odisha has adjudicated this order, impugned order. And now a minor can see in page number 16 of the brief, there are 4 notices issued before show cause notice. And at the adjudication stage, also 3 notices issued.
Whatever is same.
Whatever is said.
Whatever is same.
He has not
I think the same transactions for the same year.
Same year.
Same transactions.
Same time.
How can they be? Can you support?
But where from?
Even the constitution says the person cannot be vexed twice.
Matters. So I will agree.
No, against which you have preferred appeal. Have you preferred appeal against any one of the orders?
No, Mr. 3, my lord, that order went in favor of the petitioner. After hearing and after submission of all relevant documents.
Which one?
Annex 3, my lord.
One is in favor, and this is
Annex
passed
3
by.
in favor. Annex 1 is in favor. Your writ petition.
Achha. Which is in your favor? Annex 3.
Annex 3.
That is after participation.
After participation.
But here without participation, this are not being.
So what do you say?
How can it be?
You have to consider.
But from the source of getting that order.
That is immaterial, sir. That is immaterial.
It will be for the same transactions, for the same year, and everything, one is an expert.
Yes.
After hearing and says no liability and says the full liability.
You take instruction.
Yes, I'll take instruction, but
you will
next week.
No, which you will.
Yes, I'll not that light. I'll take instruction next one.
Next week.
Okay, my
Protection.
Yeah,
You have to take instruction with regard to expiry. That will not suspension. After participation, whatever is whatever decision taken on merits.
That will go.
That will.
Item 31.
That instruction.
Item number 31 minutes regarding 73 4B of the Finance Act. A similar order is there.
Yes. From the next one.
Item 32.
Item 32, Your Lordship, I'm on VC. I'm praying, let it come next week.
A copy of the petition has also not served on me.
The copy has not been served.
I think
The copy of the writ petition is not served.
I'll serve the copy. I'll serve the copy, Your Lordship. Let it come next week, I'll serve.
Next week on the prayer of the petitioner.
Oblige.
Item 33.
33 GST registered.
Who is for the other side? Next. Next.
Item 34.
Mr. P is under challenge. Mr. P is under challenge, but without going through the meat of the case, I am trying to give a liberty the petitioner that he will approach the appropriate forum and take participate in the proceeding.
What appropriate forum?
Here is the challenging the annexed claim. Where is it?
Oh, you want to challenge it before the appropriate forum?
My lord, actually, the challenge is the annexed fee, the payment of outright demand arise out of assessment or of past.
Mr. Manti, in the letter,
My
recovery of demand, he wants some alternative remedy. He wants to, he seeks to challenge it somewhere, not here. Now, what is your objection?
Let him find the jurisdiction where he will challenge. He does not want. So why you are standing in the way? Yes, record. What is the good name, sir?
Service, sir.
Service, sir. Letter requesting payment of outstanding demands in respect of assessment years. Assessment issued to active ward works, Baram. Income tax officer, ward works, Baram. If you have the stage of taking up the matter today, see services, sub, seeks permission to approach appropriate authority. Leave. Six leave production. To approach to ventilate the equivalence of the patient. Mr. Sebastian, senior standing counsel, income tax objection for such liberty. Situation. The restriction stands disposed with the liberty software by the petitioners.
If there be any. Approve the appropriate forum if there be any. In accordance.
Item 35.
You did prefer to big time.
Use demand.
9.
2 weeks time. 2 weeks time on the prayer.
36.
My lord, I may permitted to withdraw with the liberty to file fresh application. There has been some inadvertent errors.
Say that. Pattern
To
defects.
that extent, I'm filing a memo.
Pattern defects. I have passed an order in the morning. Permitted to withdraw means leave is granted to withdraw with liberty to file afresh.
Item 37.
Seventy-three 4B in that. 73 4B. All the things.
38.
The respondent 38 to lordship because previous matter at 23. Yes, the 23 order will relied upon by the tribunal in this case. So the lordship keep it in both the matters on 20 fixed on 3rd July. 20th.
It's identical to item number 23, my lords, of today's cause list. If my lord,
There is saying that both the will be tagged together and taken up on 3rd of July.
I'll just make one humble claim that if my lord so pleases, I can also address the court on maintainability of this appeal itself.
It's my
Take it, keeping all the points, including the maintainability of open.
So much
Whatever. Yes.
39.
May I please not? The petitioner has challenged the judgment dated 28/3/2025 passed by the Honorable Single Judge, confirming the order of the opposite party number 3, the ADM balancer, by which the direction was issued for disengagement of the appellant by following due procedure of law.
What?
On the annexure, my lord, 6. The annexure 6 has been challenged in this paper. The Honorable Single Judge. The which means confirming the order of the opposite party number 3, the ADM balancer.
Who is for the other side?
State is there, but
Yes.
it has to go to the private respondent.
Private respondent is to be noticed because he is going to be affected with that order.
Right.
So notice 4 weeks. 4 weeks.
But in the meantime, what happened?
Whatever, nothing happened.
Gets from serviceman.
Nothing happened. Don't worry.
Tendency of the rate appeal. Also, right.
Yes.
Item 40.
Both the IAS man.
Item number 40.
Petitioner had challenged the order passed by the single judge. Single judge has rejected the petition on the ground of one is the limitation, another is EGSI is not similar. There is a distinction between the two. My lord. And the judgment passed by the Honorable B.N. Makra, Justice, he said that the EGSI is similar and there is no distinction between the two. And between the two because the recruitment is same and the condition of service is same and the salary is same. My lord, I read out the judgment of the Honorable Single Judge. Para 9, Annexure 9, Para 9, petition page 138 to 153. Education volunteers who are working in the centers with the same remuneration and term and condition of the service. Both the AI and the EGS centers are government centers and opened in as per the same guideline and created by one resolution from beginning till closure of the scheme. The source of recruitment is one. Therefore, they cannot be treated as differently as it is appear non-inclusion of education volunteer working in the AI center for engagement as a Ganashiksha under Sarva Shiksha Abhiyan in the resolution dated 12/2008. My lord, kindly see the judgment. Though the petitioner, page 38, my lord, though the petitioner claimed to have submitted several representations had been to the authorities for conclusion of their case, engagement as a Ganashiksha not in a single such representation is placed record. The petitioner appears to have approached this court. My lord, they have filed 2012. Then they have 16, they have 14, 16, page 39, my lord.
Batches can be.
Page 39, several judgment has been filed and 16, 20.
Sir, notice.
18, ma'am.
Sir, notice be issued
Minor.
immediately. Requisites be filed within 3 days.
Minor.
That is returnable
Minor.
after 3 weeks.
Item number 42.
There is a delay of.
Have you served? Notice is issued?
Notice not notice.
Yes, serve the copy and come back. 3 weeks.
For admission, item 43.
3. But here is for the opposite parts number 4 and 3.
Yes.
On behalf of Mr. Naik.
What?
For the petition. Petitioner.
You're for?
Opposite part number 2 and 3.
Okay.
My lords, it will be pray for the shorter date, my lords.
Because the
My lords, shorter date.
interim order is continuing.
For the petitioner's counsel. Praying for adjournment.
Sir, justify your name.
And for the petition.
Yes, justify your name. Don't betray.
Yes, sir.
Oi,
Today's preparation, more preparation is required.
they have to meet you, you being a formidable
Warrior.
warrior. And you are a betrayal.
This is a nearby name.
And that's why I'm saying. So I told him, justify the name.
And you are pitted as Rathis and
Huh.
Kiss my so that reason will die sometimes in preparation.
How much?
See, the interim order is continuing. It's favor.
Yes, sir. Yes,
Come in the next week.
yes, yes, sir. Hello, next week.
Item 44.
Yes, sir.
My lord, the work order was placed.
And for the opposite party. Opposite party.
Opposite party.
2, 3 and 4.
2, 3 and 4.
What about 1?
My lords, I am.
Order the state.
Save me. Formal party.
Yes, where is election 9? So is election 9. Hey, election 9. Oh, it is, yes.
Annexure 9, your lord.
No, I got it. You are challenging this.
Yes, this came by your amendment. The work was awarded in favor of one Har Mahadev. And he is also a party here.
So, notices for
I have no notice was taken out to Har Mahadev.
It has to be because he is the beneficiary.
and what was it?
Inspector nothing notice and not.
No.
Initial repetition, Dharar Madhav was the party man.
On the very inception, I made him a party.
Opposite party not 5.
But the notices were issued, your lordship. My lord, may kindly look at order date, order number 1. 18/10/2024. Extra copies are served on this page. Pursuant to which they have appeared.
No, I don't think 5 and 6 have not been served.
Not taken out at all.
You have not taken notice.
No, there was no direction also, my lord.
There should be. There should be. Because I have seen the order should have been passed upon them.
Them, yes. So, my lord,
Notice after 2 weeks. Come.
notice to
Notice to this Harihar.
Harihar.
Yes.
Harar
Who
Madhav.
is 6? Who is 6?
And the excess relief valid
Another person who was
So
participating.
both will take notice. Both let me take 5 and 6. Can it pay the entire relief given by the petitioner well? Even the opposite of 2, 3 and 4 million. The Raukla smart city.
But
The
he's likely not. He's likely to be
part by this one court my lord. The unable to the
So we are giving a notice, a short notice of 2 weeks. You have waited for such a long time, you can wait for 2 weeks also.
the entire organism stall.
Whatever the two, you want, why you did not
Last
take
8 months my lord entire organism stall.
that is what we say, the 2 weeks is time, because they are to be heard. Yes, give a notice 2 weeks. And 5 requisites within 2 days. Yes.
45.
Interim order is there.
Which is operative already. To continue till next day.
Both I take out both 5 and 6.
Yes.
45.
Upon 5 and 6, yes.
3rd July.
Next.
Item 45.
Sort that.
2 weeks.
2 weeks, we have already given a short time.
On
And within 2 days, the requisites.
On the other occasions, you should have pointed out that 5 and 6 were not served copies. And there is no relief against the opposition of 5 and 6.
Oh, but they will be affected if something is passed.
That
They have to.
I am not obviously only served.
Yes.
45, sir.
And we are also mentioning certificate Mahapatra. Please grant me 2 weeks of time.
2 weeks. Yes.
Item 46.
First day after such a long vacation, we are very liberal. But from tomorrow onwards,
Item number 46.
46 are a request of that. You representative come with a discussion with any legal management officer within that. Have you got let it come someone? Day after tomorrow.
come on Friday.
Counter we have already filed.
It's like for petition. On the prayer.
Item 47.
Yes.
47.
Come for the petition in item 47.
Then come in the next week.
Notice has been challenged.
This is classification. Classification. Whether they are under GST.
Yes.
Whether that comes within the code of service rendered.
Yes.
That is not.
The tribunal come out in the scope of the court and.
Distribution service.
Yes. No, that is the tribunal. The tribunal is come in body of the courts account.
There are many judgments of
Yes. But here not.
The decision is that all the courts has a trapping of a tribunal, but all the tribunals may not have a trapping.
Yes,
of
that
a
is right. But here the act also clarified that the tribunal is something different than the courts. So therefore, what is the activity?
The basic case.
No, SBP.
SB.
SBP is that's a constitution-based decision. Yes.
Item 48.
According to your previous order, Lordship, we have paid the interest.
The last one, I think the Lordship was accommodating the department to find a counter arbitration. But I can make another rules of time to find a counter. It is the issue is related to 73 or 74 by whether it is.
Okay. Is a first extension or a second extension?
The first extension.
On the prayer of the respondent, I mean the opposite party. Time to file counter affidavit is extended
2 weeks.
by 2 weeks from date. Rejoinder?
Yes, sir.
Rejoinder, if any, shall be filed within 1 week thereafter.
Yes, sir. Make it 2 weeks.
2 weeks, matter returnable after 4 weeks.
Item 49.
Extension of time to deposit. Why? Why you could not deposit?
I deposited 1/3 amount of 1 to 48 lakhs of losses. If NHI, the government of agency is not paying the taxes, I paid the taxes by my source. I need to comply the direction of my lord, I will require 8 weeks time. I will comply to that.
What, how much time?
8 weeks time.
8 weeks. That would take us to 2 months.
My lord, the NHI is not the government agency, are not paying the period.
So what?
Minister of Roads and Highways is not paying the tax to my lord. That's why. I repeated to your lordship on 9th of June, your lordship, 1 crore 25 lakhs, your lordships.
How much has been deposited? 1/3?
But my lord, this case says 1/3, my lord.
Then remaining?
I will repeat it each time.
You have already. Yes, I quitted the land. We decided to deposit the same. Now we could not deposit the full amount. 2 weeks time. Not more than that. Don't bargain.
I'm not bargaining.
Don't bargain. Once we said 2 weeks means 2 weeks. Don't bargain.
I'm not bargaining. My difficulty is I'm not carrying the direction of my lord.
Whatever. You.
That's why we are saying 2 weeks at best. We can
my lord,
allow you. Otherwise, you.
We are going out of the way because you have admitted everything and it was done. Is really we are giving you a premium. Is out of way we are going and permitting you to deposit.
Minus 4 weeks.
2 weeks. 2 weeks.
4 weeks. I will carry on direction 4 weeks.
Okay, 3 weeks. We're not. Yes. 50.
Item number.
Time to deposit the remaining tax by 3 weeks from.
Item 50.
Keep it as an interim, keep it IA, dispose of on it.
In this eye, he has proved 3 weeks time is how much? First of the this is
Item 50.
Lordship, on behalf of senior standing counsel Radhasam Chimundra, I need 2 weeks time to file counter.
Which one?
Item 50.
50 is who is appearing?
Radhasam Chimundra, Lordship, on behalf of respondent.
Senior
standing.
Senior standing.
You didn't.
I was prepared.
He instructed me just now to take time, Lordship.
Rather cost.
Interim order to continue.